I'm just serving the court with notice because it is sometimes assumed that you keep quiet and there's nothing in the pleadings to that effect. Yes. The pleadings, this evidence that they are seeking to lead is not borne out by the pleadings, my lady.
It's not based on.
It's not based on.
Okay.
My lords, we also object to...
Do you mean the reference to the website in that paragraph?
It says moving and changing and subsequently deleted. These are very material facts. If they sought to rely upon it, they should have pleaded it. Yes. My lords, we also wish to take objection to paragraphs 6 and 7 as completely out of place. Out of place in the evidence in chief.
What does that mean? What does being out of place?
It's not admissible, my lord, because it's not admissible because it was not part of the pleadings. Their lawyer may raise that matter before the court in address, but this cannot be part of their evidence.
Part of 7 or
6 and
My
7.
view. My lords, we also take objection to that portion of paragraph 25, which starts on page 6 of their witness statement. Thus, the first respondent, in respect of the declaration of presidential election, betrayed the determination on the part of Mrs. Jean Adukwe Mensah as returning officer for the presidential election and certain officials of first respondent to have second respondent installed as president of Ghana by hook or crook. My lords, we think that this is highly prejudicial and scandalous. There's no pleading that can support this type of scandalous and prejudicial piece of evidence, and we pray that it is struck out on these grounds. My lord.
And I would remember.
Yes,
so we are clear. Is it the sentence starting from page 5? In fact,
yes.
So it starts from page 5.
Yes, you are right.
Ends at
page 2. Yes, it starts from page 5. Right. Relax. They're writing. My lords, our next objection relates to paragraph 26 from the sentence that reads, the chairperson of first respondent, Mrs. Jean Adukwe Mensah, allowed herself to be biased by her prejudice in favor of second respondent, who appointed her in August 2018 and with whose wife, Miss Jean Adukwe Mensah, has a close familiar relationship. Mrs. Mensah was doused at all material times in the conduct of her responsibilities, biased by prejudice in favor of the second respondent and against the petitioner. My lords, we pray that this part of paragraph 26 be expunged as scandalous, prejudicial, and not based on the pleadings. These are very serious material allegations of fact, and they were not pleaded. Now the next part we take objection to relates to paragraph 28, which the portion reads, the secrecy and lack of transparency regarding figures thrown up by one or more officials of first respondent seeking to justify after the event Mrs. Jean Adukwe Mensah's 9 December 2020 purported declaration, and that undermines the whole attempt at correction of what was indisputably an error and in error-driven declaration, and shows, and my lord, that's a critical passage, shows that figures were simply being cooked to achieve a predetermined outcome that had nothing to do with the actual votes cast in the presidential election.
So does your objection start from the secrecy or starts from simply being?
It starts from shows, but you can only understand the shows if you relate to it to what comes before. But the specific objection relates to the showing that the figures were simply being cooked. My lords, we say that this portion of paragraph 28 is extremely prejudicial. No facts have been pleaded to that effect and ought to be struck out accordingly. My lord, paragraph 30 of the witness statement. My lord, strangely seeks to suggest that the first respondent, because of his bias in favor of the second respondent, somehow
Could you tell us what you're objecting to? The
whole of it. Yes, the whole of paragraph 30. My lord, it seeks to suggest that the new regulations were organized by the first respondent with the object of ensuring that the process of coalition and aggregation of votes were introduced without any good reason. My Lord, is talking about a piece of legislation. My Lord, it is the witness may not speak to the legal validity of a piece of...
Mr. Kutampo, so is it your objection that it's not based on pleadings, or that it unduly prejudices, or it's scandalous? You've told
My Lord,
us
it's
three
not
grounds.
based on the pleadings, nor is it, and furthermore, it is unduly scandalous. And my Lord, our next objection. No, I don't. The next objection, my Lords, relate to paragraph 32. My Lords, this was not pleaded by the respondents, the petitioner, and my Lord, it relates to 275 summary sheets results. My Lord, nowhere in the petition has there been any reference to any 275 summary sheets. And the petitioner had all the opportunity to do so if he intended to rely on this evidence. In the trial. He failed to do so, and is seeking through his witness statement to improperly introduce it through the back door. Should be, and we pray, therefore, that it be struck out. My Lords, indeed, if your Lordships take a look at the petitioner's amended petition, even exhibits were attached to the petition when they should not have been. And so they had every opportunity, even at the time of filing their petition, to follow that flawed tradition. But they didn't. And now, when they asked to write their witness statement, they introduced this huge piece of evidence which they hadn't pleaded. We ask that it be struck out as not based on the pleadings. And consequently, paragraph 33, which is a consequence of paragraph 32, should also, in similar fashion, be struck out. I hear you. My Lords, as we've indicated, it is well established that a party's pleadings are fundamental in determining the case he or she intends to make during trial. The party's pleadings also notify the other side of the case that he will meet in court. My lords, the significance of pleadings have been set out very clearly in the case of Hammond and Odoi. 1982-83, 2 Ghana Law Report, 215 at 1215 at 1235 to 1236. My lords, I know that this statement of the law is very well known to your lordship, so I will not detain you with reading it. My lords, I wish further to refer your lordships to the case of Adejumo versus Abegunde and another, reported in 1965 Ghana Law Report 499, 1965, my lords, Ghana Law Report 499. Which holds that in holding one. Now this is the Supreme Court. Holding one to the effect, quote, although evidence is inadmissible to prove material facts which have not been pleaded, yet when such evidence is adduced at a trial without objection from counsel, the trial judge is bound to take it into consideration. My lords, we are making this objection so as not to fall into that trap. And my lords, we wish, in addition, to refer to the evidence decree. Evidence Act now, my lords, Evidence Act. Section 51, my lords, which reads as follows. For purposes of this decree, relevant evidence means evidence including evidence relevant to the credibility of a witness or hearsay declarant, which makes the existence or non-existence of any fact that is of consequence to the determination of the action more or less probable than it would be without it. And sub 2 reads, all relevant evidence is admissible except otherwise provided by any enactment. And sub 3 states, no evidence is admissible except relevant evidence. And my lords, Section-
Mr. Tuampa, I'm not clear what lessons you want us to draw from
My Lord, I'll shortly demonstrate if I'm going to. Section 52B states the court in its discretion may exclude evidence, relevant evidence, if the probative value of the evidence is substantially outweighed by the risk that the admission of the evidence will create substantial danger of unfair prejudice or substantial danger of confusing the issues. Now, my lords, the relevance of this piece of these provisions of the Evidence Act is that they confirm the position that any evidence that will be led must be based on the pleadings and be related to an issue in dispute. And that pleadings, evidence that spring from nowhere surprises the other party, and where they do cause, where they provide a danger of substantial or unfair prejudice, may be disallowed by the court. And that is why we believe it is relevant. My Lord, it is for these reasons my Lord, with all due respect, my attention has been drawn to paragraph 37 also. Yes, the last of any paragraph, where the witness states, I quote, this conduct of certain officials of first respondent in parting the votes of certain respondents is in fact indicative of a well-hatched and sustained pattern of manufacturing numbers unrelated to the actual votes collected at the various collation centers with the sole aim of achieving the predetermined goal of the chairperson of the first respondent and a number of officials of the first respondent to have second respondent unconstitutionally and unlawfully installed as president. My lords, this paragraph is extremely scandalous, and what makes it worse is that apart from the so-called 4,000 plus padding that they allege, and they have not provided any further evidence or made any further pleading, indicating that there's a well-hatched and sustained pattern of manufacturing numbers unrelated to the votes. There's nothing in either their petition or there's nothing in their petition to that effect. My lords, I think it is significant that whilst the petitioner has been making these really scandalous allegations, he has not provided one shred of evidence of his own tabulation of votes. Nothing throughout the petition, not even in the witness statement.
Mr. Kutuampa, you take advantage of that. Why are you worried?
No, my Lord, I'm saying that to show how totally unacceptable paragraph 37 is. And it ought to be struck out.
Mr. Kutuampa,
Yes.
let me chip in. You see, the pleading is different from evidence.
Yes.
Pleadings can be struck out on the basis that it's scandalous. Yes. But this is evidence.
And my Lord, if it cannot be struck out, it should not be admitted.
No, if a pleading is scandalous,
Yes.
yes, it is a basis for striking out.
Like,
Yes, but the evidence is quite different from a pleading, except that the evidence takes its root from the pleading.
yes, my Lord. And our case is that these pieces of evidence are not based on the pleadings.
No, but if you... Yes, you must know the basis of...
My Lord, they are not based on the pleadings, and they should not be admissible. Being scandalous. My Lord, we pray accordingly.
Also, what is wrong with paragraph 6 and 7? Paragraph 6 and 7. Yes, what is wrong with that? This is a fact.
Look at it carefully.
Yes.
Yeah, what is wrong with that?
My Lord, our view is that those two paragraphs are not matters for his evidence in chief.
They are not matters of for evidence in chief.
Yes.
No. So assuming we are doing oral trial and the witness is in the box, can't counsel ask him whether in the course of this trial his file notice limit? Can't counsel ask him
My Lord,
or whether in this trial he filed interrogatories? Can't he be asked?
my Lord, in the first place, we want to make the point that the witness is a witness. It's not a representative of the petitioner. He's a witness, my Lord. And if your lordships look at the witness statement, he doesn't indicate that he has a power of attorney and is speaking on behalf of the petitioner. He is a simple witness of the petitioner.
To find out. When we led him, he said he was on behalf of the petitioner. So I was going to ask.
He's a witness.
He's a witness of the petitioner. Okay.
One statement. Yes, my Lord.
What is your view about this paragraph? Because my understanding of why we are here is that we are dealing with the validity of the election of the candidate. And when I look at the evidence, in 2020, the witness just stated numbers application 275 summary sheets, 30,000 comments, 30 million 213 elections like that. How would that affect your case? When there's issue, you see, we are not dealing with the High Court trial. We are not in the High Court. We are in the Supreme Court exercising a special jurisdiction over the validity of election of a candidate. So you have to limit everything, your submissions and your cross-examination, to the validity of the election of the candidate and not a general trial in the High Court. So you're complaining about 32, 33. How would that affect your case, the validity of election of the candidate? Has the witness made any assertion that because of that, votes and other things and whatnot? So you look at it. If there's nothing, let the trial proceed. Otherwise, we'll be going through this banter and we'll spend the whole time raising objections and this and that. So let's focus on why we are here.
My Lord, that is precisely what I'm trying to do. My point, my Lord, is that the petitioner in his petition has never said anything about summary sheets. Indeed, the petitioner in his petition, in our view, has not challenged the validity of the election. It has simply picked on some errors in the announcements and the tabulation of the results. He has not
And in these two paragraphs, 32
Yes.
and 33,
Yes.
the witness is also not saying anything about the validity of the election.
Yes.
So why not keep quiet over it? That's
my
what
Lord-
I've been telling my students in advocacy lectures.
Yes, my Lord, we will not keep quiet over it because it could be prejudicial. It may cast an unnecessary cloud over the elections. It is not being pleaded, and my lords, I believe that they cannot lead evidence that is contrary to their pleadings.
Thank you.
But I want to know whether Mr. Minuvo has something to say about the witness statement. Yes, Justin.
Yes, my Lord. My Lord, I have nothing more to add to what Mr. Otuampo has said. Thank you. I associate myself with his submissions.
My Lords, we have to deal, I believe, with a very practical issue before I get into the responses. Quite a lot of objections have been raised, more than 10, I believe. If it were a trial in which oral testimony was being given, in evidence in chief, there would be a series of objections at different points, and then one could take it up. And the practical difficulty I'm talking about is that as he was raising the objections, we were busy trying to deal with it. And we're frankly not, I should speak for myself, I'm frankly not sure that I have listed all the objections.
Mr. Chikata can
and the
help
grounds.
you.
So,
Mr. Chikata, we can help you.
yes, very
We
well.
captured them all.
Yes, very well. So what I was going to say, my lords, is that as we proceed with the responses, we may need to come back to your lordships for the statement that you have recorded in respect of the objections, so that the answers will be appropriate in terms of what your record shows. That's what I meant by the practical solution to ensuring that we are addressing all the objections. But we're ready to respond to each of the objections and guided by your record of the objections.
It appears the first objection, I hope you recorded the basis for the objection.
As I said, we're trying hard to record it. But
No. I know that it's very difficult to get there. The very paragraphs he referred to. Yes, I'm talking of the grounds for the objections, which were what that.
oh yes,
it was based on the pleadings.
the two grounds that he said
Yeah,
at the
fine.
beginning. Yes,
Thank you.
that.
Yes, the first one was in respect of paragraph 21. Paragraph 21. Then the second, we went back to paragraph 6 and 7.
Yes.
Yes. Then he went to paragraph 25. Paragraph 26.
25 portion.
The portion, not the whole.
From
The latter part of paragraph 25. Yes. Yes. Then he went to paragraph 26. Then went to paragraph 28, paragraph 30, paragraph 32, paragraph 33, paragraph 37. Yes. Then I think that is all. That is all. Please,
Yes.
can I go over it?
I have the paragraphs, but as I go on, the particular ground that he gave for each paragraph, I may ask for
Yeah,
your
no problem.
clarification.
No problem.
Yes, I have the paragraphs all right. No, yeah. Now, my Lord, the first paragraph, and my Lord, I start off with the fairly elementary statement of the law that pleadings are not meant to be evidence. And my lords, Rule 7 of Order 11 makes clear that subject to this rule and Rules 10 to 12, every pleading shall contain only a statement in a summary form of the material facts on which the party pleading relies for claim or defense, but not the evidence by which those facts are to be proved. And the statement shall be as brief as the nature of the case admits. Now, my lords, that's a fairly elementary and well-known rule. And if we take the various objections, paragraph 21 is that, and paragraph 21 follows paragraph 20. So if I may first refer to paragraph 20. In this unsigned press release, first respondent introduced new figures for the total valid votes cast in the presidential election held on 7th December 2020. A copy of the said press release is attached and marked as Exhibit B and was available on first respondent's website, www.ec.gov.gh, as of 11:45 GMT on 29. So even as late as just before the petition was filed, we were pointing out that that document was available. And paragraph 21 is making reference to the fact that following that press release, the results being published by first respondent on this website became moving targets. Now that's evidence in respect of what happened to the numbers that were provided for in paragraph that were mentioned, that were alluded to in paragraph 20. And becoming moving targets, subsequently deleted the changing figures from the website. That is material evidence that undermines the figures that were in that press release. Because the figures in the press release, as we indicate, an unsigned press release that's, again, very clear. And subsequently, those were themselves being changed. I cannot see how this is immaterial. And my lords, particularly in a situation where the witness statement of the first respondent, that witness statement itself has different numbers from the numbers in the press release and the numbers in the declaration. I cannot, with the greatest respect, see how evidence about changing figures is not material in these proceedings.
Mr. Speaker, that is not the point. It says that this paragraph 21 has not been pleaded. It doesn't take its source from your pleadings. So perhaps if you look at your paragraph 28 and 29 of the petition,
yes,
you may be able to respond to it. The ground is that it has not been pleaded.
Let me just...
Yes, on the pleadings.
yes.
If you look at your paragraph 28 and 29, yes, so look, so you can help it.
My lords, indeed, in our paragraphs 28 and 29 and 30 of the pleadings, we state on 10th December 2020, an unsigned press release of first respondent claimed that its chairperson, Mrs. Jean Adukwe Mensah, had inadvertently, in quotation marks, used the figure of so-and-so. And then we continue in 29. In this purported corrective press release, first respondent introduced two completely new figures for the total votes cast in the presidential election. Thus, there was no correction, properly so-called, since to be valid, a correction of a prior mistake must correctly name the mistake to be corrected. In this case, the mistake to be corrected was itself mistakenly stated. The numbers so-and-so are completely different. And then paragraph 30, in seeking to justify the new figure put forward in the press release, various adjustments to figures of votes cast for various candidates are made without any explanation and with a total lack of transparency. That is pleaded. And then it goes on in paragraph, paragraph 31. I'm sorry.
So go to paragraphs 6 and
Now, in paragraph 6 and 7, my lords, and your lordships will recall that in following your orders in terms of the filing of the witness statements, we actually drew attention to this issue of the request to admit facts, issues which normally would be part of the pre-trial and which therefore affects how we prepare our witness for the trial. So, my lords, the point of paragraph 6 and 7 is precisely to indicate to your lordships the parameters within which his evidence are being placed, because those parameters are...
We are worried because Mr. Esiedu Ketia is not the petitioner. He's not a party, strictly speaking. He's just a witness, as we rightly pointed out. So let's look at it in
Yes, but my lords, he is a witness of the petitioner. Yes. And as a witness of the petitioner, he can, yes, he can, my lords,
as a witness,
he can swear to matters that are within his personal knowledge. And those matters include processes which he is aware of. I mean, those processes are, in fact, a matter of public record, literally.
Because, you see, we don't want, sir, we don't want a situation where, under cross-examination, a question is put to him. Do you know anything about notice to admit?
My lords,
No, the situation can arise because, you see here, he's or not.
My lords, he
is or not.
And I'm sure that he will be able to take care of himself.
No, we want to avoid a situation where maybe...
No, my lord, with respect,
we just want want to streamline the way things should be done.
Yes, and my Lord, respectfully, my Lord, that's why I respectfully...
Let's move. Please, let's move.
If I, well, my Lord, frankly, there is no difference in terms of these particular paragraphs, because the petitioner is not himself the lawyer filing those processes. The petitioner, yes, but the petitioner gives the instruction, and a witness of the petitioner who is as aware as anybody else of those processes can speak to those processes, because he is a witness of the petitioner, and as a witness of the petitioner, he familiarizes himself with processes that are filed. And in fact, more importantly, as a witness, and the point of those paragraphs is very clear, as a witness, he is indicating to the Honorable Court that I am aware of these, and that is guiding what I have to put in my witness statement. That is part of the point. And my Lord, and that is why, in fact, before he went to the witness box, I did draw your Lordship's attention respectfully to the fact that we wanted guidance on whether we needed leave subsequently after those, and your Lordship said he should go into the witness box. So my Lord, I have no doubt that the witness is able to address those issues in terms of what has been done on behalf of the petitioner. I have no doubt about that. In respect of 25, in respect of paragraph 25, and again, paragraph 25 can only be read in conjunction with the prior paragraph. In announcing the various so-called corrections and corrections of corrections, no officer of first any consultative process involving petitioner or his accredited agents, nor did Mrs. Jean Adukwe-Mensah, returning officer for the presidential election, or first respondent basis to revise the figures as to the votes he, petitioner, and or second respondent obtained, much less give them an opportunity to observe or participate in the processes by which those revisions were purportedly effected. That is 25. And in 25, it goes on this, referring back to what has just gone on. This was clearly contrary to the responsibilities and first respondent as a whole had by virtue of Article 23 of the Constitution, which provides that, quote, administrative bodies and administrative officials shall act fairly and reasonably and comply with the requirements imposed by law, and persons aggrieved by the exercise of such acts and decisions shall have the right to seek redress before a court or other tribunal, unquote. In fact, the ever-changing figures put out in an unsigned press release and what was posted on the website of the first respondent in respect of the declaration of the presidential election betrayed the determination on the part of Mrs. Jean Adukwe-Mensah as returning officer for the presidential election and certain official of first respondent to have second respondent installed as president of Ghana on 7th January 2021 by hook or by crook. Now, my lords, in the pleadings, in paragraph 33, My lords, in fact, if I may start actually from paragraph 20 of the pleadings. I may even start from 19, because in 19 is the statement, first respondent and his chairperson, Mrs. Jean Adequate-Mensah, are required in the conduct of their responsibilities in respect of elections to comply with the Constitution. Paragraph 20, in declaring second respondent as the winner of the 2020 presidential elections on 9 December 2020, the chairperson of first respondent, Mrs. Jean Adequate-Mensah, acted in flagrant violation of the 1992 Constitution.
Mr. Chikata,
Mr.
Chikata,
yes.
Could you hurry to where it is your pleading that she intended to install the second respondent by hook or crook, or where this evidence takes its roots from?
In paragraph 21, we say that first respondent, she was required to act fairly, reasonably, candidly, and not arbitrarily or capriciously. And then we go on in paragraph 24. We go on to point out that she was required not to be biased either by resentment, prejudice, or personal dislike, and also requires them to exercise discretionary power in accordance with due process of law. So we are pleading the fact that these were requirements placed on her, and evidence to show that she did not comply with those requirements is certainly available on the basis of those pleadings. And as I indicated, in relation to law,
You then go on to draw the conclusion or to conjecture that she was determined to declare the second respondent as president by hook or crook.
my lord,
That is just
my lord, that's
conjecture.
not a conjecture. That's not a conjecture. If they want further and better particulars of it, of course they're entitled to ask for further and better. But it is not a conjecture. And we are saying that these are matters that are demonstrated in the various pieces of evidence, especially relating to ever-changing numbers on the website that will obviously be before you. And in fact, most of these are not denied. It's not denied that there were changes and ever-changing figures. It's not denied that, you know, what is in the answer, the figures in the answer are different from every other figure that we've seen in these proceedings. Now, we are saying that all this is evidence of a predetermined agenda. That is, you know, my lords, in proving facts, in proving...
Mr. Chikata, this is really what I wanted you to show, that the statement or the pleading that there was a predetermined agenda to end in a particular way. That's what I'm trying to find from your pleading.
That is a necessary implication from the ever-changing figures that were supplied right up until the point of the answer. And my lord, that is a matter that circumstantial evidence is obviously permissible in proving facts. So
Hold on, say. So your response is that this allegation of hook or crook is actually intended to lead us to a conclusion that is made out of inference. Is that what you're saying?
it's based out of the circumstantial evidence, the compelling circumstantial evidence.
It's an inference. It's an inference that you are making. And you know, inferences are alien.
Yes,
In evidence. You can be an address, but not evidence.
yes, my lords, I said we are giving circumstantial evidence on the basis of which conclusions
What you are describing as circumstantial evidence is an inference. You are making an inference. And evidence, we don't do inferences. You can address on it.
My lord, these are not inferences. We are saying there was a predetermined agenda, and we're saying that that predetermined agenda is evident from the ever-changing circumstances and from the refusal to act in accordance with the responsibilities to be fair and candid. We say in paragraph 22 that she refused to entertain legitimate concerns placed before her regarding errors in the data she was proceeding to make the declaration on. We say in paragraph 23 that prior to her making the said purported declaration, Mrs. Jean Adukwe-Mensah had been notified by agents of petitioner of certain material errors in the figures collated, and then refused to accept a letter written by the NDC to her, raising some of these concerns. But if evidence cannot be given in relation to all these matters and how they lead to the inevitable conclusion of a predetermined agenda, then respectfully, I don't know what else we're supposed to do in terms of providing evidence. We go on, my lords, I'm not finished. We go on in paragraph 30. In paragraph 30, in seeking to justify the new figure put forward in the press release, various adjustments to figures of votes cast for various candidates are made without any explanation and with a total lack of transparency. My lord, I mean, one should, with respect, take cognizance of the various elements of our paragraphs in the pleadings. The fact that there's no explanation, there's a total lack of transparency, these are all things that have been pleaded. And if evidence is being led in terms of the predetermined agenda and the determination by hook or by crook to arrive at a certain result, I cannot see how that evidence can be regarded as objectionable in any way. They can cross-examine on that evidence. They can seek to discredit him and say that he has no basis and whatever. But we cannot say that that evidence is not admissible. Now, my lords, I believe the next paragraph was paragraph 26. The Gazette notice is required to be based on the declaration actually made by Mrs. Jean Adukwe-Mensah as the chairperson of the first respondent. I'm sorry, that's our pleading. 26 of the witness statement. Yes. The 26 of the witness statement is where the chairperson of first respondent and first respondent are also not required under Article 296 of the Constitution to be biased either by resentment, prejudice, or personal dislike in exercising any discretionary power. They're required to exercise that power in accordance with due process of law. The chairperson of first respondent, Mrs. Jean Adukwe-Mensah, allowed herself to be biased by her prejudice in favor of second respondent, who appointed her in August 2018 and with whose wife, Mrs. Jean Adukwe-Mensah, has a close familial relationship. Mrs. Mensah was thus at all times, at all material times in the conduct of her responsibilities, biased by prejudice in favor of the second respondent. Now, my lords, we have again pleaded the requirement of compliance with Article 296B. And in turn, in their answer, paragraph 39, paragraph 40 of their answer, in further denial of the petitioner's claims, first defendant says that it complied with all the processes and procedures laid down by law for the conduct of the 7th December 2020 presidential election with fairness to every candidate and without malice, ill will, or bias against anyone. So there's a denial of our allegation. There's a denial of that, and therefore a witness that is speaking, and she actually goes on in paragraph. The answer goes on in paragraph 41 to talk about, in a bid to enhance transparency and public participation, it took certain steps. So, my Lord, clearly the answer of the first respondent shows her recognition that the issue of her bias is part of what has been pleaded. And she is asserting in paragraph 40 that she did, first respondent, well, in fact, respectfully, that paragraph just says the first respondent. It doesn't speak specifically about her. So we should take the words as they are. The first respondent says it complied with all the processes and procedures laid down by law for the conduct of the 7th December 2020 presidential election with fairness to every candidate and without malice, ill will, or bias. So clearly there is an issue that is before this court of whether there's bias to anyone or in favor of anyone or not. There is an issue.
So, where in your pleadings did you plead and in a way is related to the wife of the second respondent? Where?
My lords, we plead the 296B bias by either by resentment, prejudice, or personal dislike.
Honestly, by the use of pleadings, we don't plead law. We don't. 296 is a constitutional provision.
Yes, my lord, we plead law in the context where certain facts related to the operation of that law are being contested, because we have to state that the Constitution has this requirement in order to point out that that requirement has
Okay, but then they went further, as you rightly pointed out in, I think, was it paragraph 40? Yes. And then they pleaded in answer that they complied with the law and that they were not biased, and they went through with the due process as required by law.
So
yes, but then if you go further and we are concerned with the last paragraph of paragraph 26. We are not comfortable with that.
That is their problem.
That is their problem.
The paragraph starting from the chairperson of first responder, Mrs. Jane Aduke Mensah, allowed herself to be biased by her prejudice in favor of the second responder, who appointed her in August 2018.
Yeah, that is...
And with whose wife, Mrs. Jane Aduke Mensah, has a close familiar relationship. Mrs. Mensah was thus, at all material terms in the conduct of her responsibility, biased by prejudice in favor of the second respondent and against the petitioner. They say that this has not been pleaded. This fact, this evidence, is not based on the pleadings.
We are saying respectfully that this, what is contained in the witness statement, is evidence of the pleading of non-compliance with Article 296B, because that is part of our case.
No, but you must plead before. I mean, if the thing does not even appear in your pleadings, so how can it turn to become evidence? The thing does not appear in your pleadings. We have not read anything like this from your pleadings, from the petition.
Don't you think the close familiar relationship should be a material fact that Based on Order 11, Rule 7, you should include in your pleadings?
My lords, I am not of the view that that by itself is a material fact that should be reflected. And my lord, let me be clear. Let me be clear. Bias could be related to a number of different factors. A close familial relationship is a potential element. And if, in spite of the close familial relationship, there is action taken that reflects due process, transparency, and everything, then in that situation, the close familial relationship would not affect the conduct of the proceedings. So it is really a matter of evidence whether in the context, in the circumstances that we're dealing with here, whether we have a situation in which that familial relationship has actually affected
This is your evidence.
to that.
This was not in your pleadings. This was not in your pleadings. Are you not taking her by surprise?
Well, we don't believe that this takes her by surprise because this, I'm sure, is
No, I mean legally.
There are facts that are very one to in fact, there are facts that are.
But we don't know.
Well,
We're sitting here, we don't know. Until we read this, we didn't know.
Okay.
Okay.
Now, we are saying that in respect of paragraph 26, I'm concluding my response on paragraph 26. Am I allowed to do that? We are saying that in response to paragraph 26, these allegations of bias are sufficiently referenced in our pleadings in relation to the operation of Article 296B. And we're saying that the denial that is contained in paragraph 40, that denial indicates that the petitioner is not taking the first respondent by surprise in respect of the allegations of bias that are in the witness statement. Now, that's in paragraph 28. I understand that the objection is to a portion of that paragraph, and if your lordships could clarify which portion. Yes, the secrecy and lack of transparency regarding the figures thrown out by one or more officials or first respondents seeking to justify after the event, Mrs. Jonathan 9th December 2020 purported declaration undermines the whole attempt at correction of what was indisputably an error-ridden declaration and shows that figures were simply being cooked to achieve a predetermined outcome that had nothing to do with the actual votes cast. My lords, I have referred already to our pleadings in respect of transparency, and I have also referred to our pleadings in respect of these changing figures. And if I may go over that again for the purposes of this response. And We start from paragraph 8. The claim that the percentage of votes cast, votes obtained, paragraph 8 of the amended petition. The claim that the percentage of votes obtained by second respondent was 51.595 of the total valid votes that she herself distinctly stated to have been 13,434,574 was a manifest error, as votes cast for second respondent would amount to 50.098 and not the 51.595% erroneously declared. And then in paragraph 12, which I referred to before, we indicate that if the total number of votes standing to the names of each of the presidential candidates is summed up, this will yield a total number of valid votes cast of 113,121,111, a figure that is completely missing from the purported declaration by Mrs. Jean Aduko-Mensah on 9th December 2020 and the purported rectification on 10th December. So we have already intimated these initial changes. And then we proceed, as I indicated previously, we proceed to make reference to the fact that this is in paragraph 22, which I referred to before. Mrs. Jean Aduko-Mensah predetermined prior to the 7th December 2020 presidential and parliamentary elections that she would announce the result within 24 hours after the close of polls. Consequently, she refused to entertain legitimate concerns placed before her regarding errors in the data she was proceeding to make the declaration on. Prior to making the said purported declaration, Mrs. Jean Aduko-Mensah had been notified by agents of petitioner of certain material errors in the figures collated, and then refused to accept a letter written by the NDC to her, raising some of this concern, and the letter is attached. And then we also further indicate the lack of transparency that was involved in the purported corrective press release. And this we do in paragraph 30. In seeking to justify the new figures put forward in the press release, various adjustments to figures of votes cast for various candidates are made without any explanation and with a total lack of transparency. There is a direct reference to the lack of transparency in that paragraph. And we go on further in paragraph 31 to say that the so-called rectification of the errors in the purported declaration was itself egregiously wrong, and we go on to provide. So, my lords, in paragraph 33, if Mrs. Jean Aduko-Mensah, as returning officer of the presidential election, had determined in good faith that her declaration on 9th December 2020 was in error, her constitutional duty to be fair and candid, and my lord, that explains why we had reference to the constitutional duty in the pleadings. That her constitutional duty was to be fair and candid, required her, among other things, to acknowledge the error, set aside her erroneous declaration, and proceed on the path to correcting her error, respecting the rights of candidates to participate in the processes towards the making of such a declaration. So we indicate what transparency required. We didn't just say lack of transparency at large. And we go on in paragraph 34 to say that the unsigned press release of first respondent has no value in the determination of the validity of the declaration that Mrs. Jean Aduko-Mensah made on 9th December 2020, especially as the issue of the release was not undertaken transparently and in accordance with due process of law and established practice, including the participation of affected candidates through their respective agents. So we have pleaded everything that we need as a foundation for pointing out that what was done secretly, in the sense that it was done, without reference to any of these candidates, completely by themselves, and not in accordance with the legal requirements for the participation of agents of the candidates. I mean, all these paragraphs that I've adverted to are specific in reference to lack of transparency, lack of contact, consultation with anybody, and I cannot see how the witnesses' indication that the secrecy and lack of transparency regarding figures thrown up by one or more officials of first respondents seeking to justify after the event, Mrs. Gina Adukoya Mensah's 9th December purported declaration, undermines the whole attempt at correction of what was indisputably an error-ridden declaration, and shows that the figures were simply being cooked to achieve a predetermined outcome that had nothing to do with actual votes cast in the presidential election for the various elections, for the various candidates. So, my Lord, the point we are making is that there has been sufficient basis laid in the pleadings for there to be evidence that shows that figures were just being cooked, because the figures are coming out of nowhere and without reference to anything that is transparently communicated to anybody. My Lord, with the greatest respect, I find it very difficult to see how any objective observer of the ever-changing figures that have been put forward can fail to see that we are not justified in talking about figures being cooked. And my Lord, figures being cooked is simply an indication that the figures are, just being thrown up, unrelated to valid votes being cast, counted, and collated, which is what it should be. So, my Lord, respectfully, we would submit that there is a basis in our pleadings about lack of transparency, lack of due process, in respect of paragraph 30, and if your lordships could again perhaps read out what the ground, the specific ground is, so that...
Are you asking for help with paragraph 30?
Yes.
30, the whole of paragraph.
Yeah.
On the basis that...
Yeah.
On the basis that the witness cannot speak to the legal validity of the legislation referred to, that is CI 127.
Okay, my lord, this again is not a pleading of law at all. This pleading states in the new regulations promulgated, and it's not an issue about the validity of the constitutional instrument. That is not the issue. In the new regulations, this is just a factual statement about how the new regulations operated. In the new regulations promulgated by first respondents, CI 127, it now interposed between the strong room and the constituency collation centers without any good reason, another layer of collation at its regional offices with regional summary sheets. That is a fact. It did that as a result of the constitutional instrument. This led to results being sent from regional collation centers which were at variance with the results collated at constituency collation centers as a result of figures being altered by officials of first respondent. Exhibit C provides sample details of wrong aggregation of valid votes on the face of the summary sheets of some 11 constituencies. The exhibit shows that the sum total of votes, of valid votes obtained by all candidates varies from the figure recorded on the face of the summary sheets as the total valid votes from each of these constituencies. Now, my lords, the statement there is quite clear about the interposition of the regional collation centers as a source of errors. And an exhibit, Exhibit C, is also provided. In the petition with the sample details. Now, my lords, it needs to be clear. It needs to be clear that in this petition, unlike perhaps in the 2012-2013 petition, the petitioner did not come to court saying that and now 4 million votes of voters who have voted. And now then, because in some cases print sheets didn't have presiding officer signature or there were duplicate serial numbers. In the nature of this petition, the petitioner is saying that a certain declaration was made on the 9th of December. It was publicly made, we all heard it, and the petitioner is saying that when you look at figures in that declaration itself, those figures do not amount to compliance with a constitutional provision duly. That's what now, in this paragraph 30, what the petitioner is seeking to do is precisely to provide, as it is said, a sample of wrong aggregation, and the petitioner is attributing that to the interposition of the regional collation center. So that is the import of that paragraph, and that import is related to the lack of transparency pleadings that we clearly have.
Mr. Chikata,
yes.
Your pleading indicates that that interposition comes from the new regulation, from the law. Isn't that your pleading?
The new regulation is, I didn't hear the last bit of
The testimony of the witness is that the interposition,
the new regulation
interposed, yes.
Yes.
And that's the source of the trouble. That's the source of the complaint.
Yes, in its operation, the way it operated, the way this new regulation was operated in practice.
And the objection, the objection is that it seems to suggest that the new regulation of first respondent was about ensuring that the process of collation and aggregation of votes were introduced without good reason. And yet that was introduced through a law. It was a law that provided that framework. And that is the complaint.
It was subsidiary legislation made by the first respondent, and the witness statement is indicating that the operation of that, it was a matter of law, but you can operate a legal provision in a manner that leads to wrong results. That's what we're saying. I mean, you could operate the creation of regional centers in a transparent way, which does not lead to the results.
And so once again, you are inviting us to make an inference, or what?
My lords, I'm not inviting just making an inference. I'm saying that we have pleaded a lack of transparency. We have pleaded a lack of consultation in respect of how these figures popped up. And the witness statement is showing one of the ways in which that lack of transparency was demonstrated in the actual conduct of the first respondent. That is what the witness statement is seeking to do as a matter of evidence.
But Mr. Chika, there is nothing in the petition about this, let me call them collation issues. There's nothing in the petition that the collation process resulted in changed figures or figures changing.
We have pleaded the fact that numbers were being changed by the first respondent without any transparency.
Now,
Now,
Mr. Chika,
those
this
numbers,
is such a big issue that if that is your case, it should be in the petition that A, B, C, D, from this polling station to this constituency, to this regional collation center, these figures changed. There's nothing about this in the petition.
my lords, the petitioner is not the returning officer for the presidential election.
Oh, but he's the one challenging
The petitioner, may I answer you? The petitioner is challenging, firstly, on the basis that you made a declaration in which you put forward certain numbers. On the face of your declaration, those numbers do not warrant your exercising your constitutional responsibility the way you did. That is the basic point of the petition. My lords, if I may finish my answer, because I believe it's important for the answer in its fullness to be heard. The petitioner makes clear that her challenge is based on the fact that the person who is a returning officer, that person has purportedly made a certain declaration of someone as having won the election. And yet the figures that she has put in as the basis of her declaration, those figures do not warrant her declaration. That is the heart of this matter. Now, my lords, at the heart of that petition is this issue about the numbers that were acted upon by the first respondent. First respondent puts forward an answer in which effectively first respondent says, I am actually admitting that there were errors. That's what first respondent is saying. First respondent is saying, I'm admitting there were errors, but one, they were inadvertent. And they were corrected by a press release on the 10th of December 2020. We point out that the so-called correction itself contained mistaken figures. We point that out very clearly. And we further point out that those figures kept changing right up until the point where we have in the witness
My lords,
statement.
with respect, counsel has been repeating the same things for the past 15 or 20 minutes. It's the same thing he's been repeating.
My lords, I don't know whether that's meant to throw me off the course of my argument, but I think with respect, this is intolerable with respect, because I was in the middle of a sentence actually, and you know, it is not appropriate, you know, to make this kind of interjection.
Yeah, please, when you want to raise an objection, it has to be timelessly raised. Yeah, so that, yes, you don't disrupt.
My Lord, I thought I was actually raising it timelessly.
My lord, I believe I was in the process of explaining that at the heart of the petitioner's petition before this court is a challenge to the declaration. And it's not just a challenge about figures, but it's a challenge related to the constitutional consequence arising from those figures. And we're saying that we're saying that in effect, the answer of the first respondent actually acknowledges that there were errors.
Excuse me, you're supposed to be speaking to paragraph 30, which is about the original collation. And the question from my brother on my right was that there is nothing in your pleadings about the collation process.
My lords, with respect, the point that I was leading to, if I may be allowed, the point that I was leading to is that because the first respondent is the official responsible for those processes, and the first respondent in the answer tabulates the so-called, you know, primary, secondary, tertiary, quaternary stage, and she relates to the collation process. The witness statement is also in response to the matters in the answer of the first respondent, because the witness is addressing the case of the first respondent as well. The witness has to respond to the case of the first respondent, and the case of the first respondent is that she went through, you know, these 4 stages, and you know, so she is in effect explaining herself in terms of her conduct, and we are saying that on that basis, the witness is entitled, because my lord, if you were giving oral evidence, if the witness were giving oral evidence, I would be entitled to lead him and say, in the answer of the first respondent, they have said they went through this and this. What do you have to say to that? My lord, that's perfectly legitimate if I were leading him in the normal course.
Counsel, in fact, with the greatest respect, my problem is this. In the pleadings, in the petition itself, the petitioner did not raise any issue with CI 127, the law that regulated election.
And the petitioner does not seek to raise an issue about the lawfulness
But by paragraph 30 of the witness statement, the witness is trying to raise issue with CI 127.
No, my lord, the petitioner is raising an issue over the fact that the first respondent, without good reason, interposed that regional collation center. My lord,
you see, that were the provisions in CI 120. That was the regulations that regulated or governed the elections, the conduct of the elections. And if you did not raise any issue with it, that the first respondent did violate CI 127, and in your evidence you try to raise issue with how, for the first time, how the there have been changes in national room to constituency coalition. That's what CI 127 said the election should be conducted. So, and you never raise any issue with it. Then in evidence, you try to raise issue indirectly.
My lords, with the greatest respect, I believe that we are confusing an issue about whether we are seeking to challenge or raise an issue with CI 127. And we're saying that that is not the objective. But CI 127 has to be executed. And if the petitioner, in making this interposition without good reason, if the petitioner has, as a result, had problems in the collation which we seek to demonstrate with some samples, that respectfully is an answer to their attempt to suggest that they did everything according to the processes that they outlined in their answer. My lords, I don't think there's any doubting that in their answer, if my lords want me to refer to the specific passage of the answer, it is from paragraph 5.
Mr. Chiketa, we don't want you
Yes, so
to read that one. We are familiar with that.
So my lords, if I could, in oral testimony, leading him, if I could ask him, what do you have to say to paragraph 5 of the answer of the first respondent, which says they went in accordance with this and this and this and that. My lord, would he not be able to provide the answer that is provided in paragraph 30? Respectfully, he would be. I mean, he absolutely would be. Because the respondent, the first respondent, has put in issue exactly those whole processes. Those processes come into the dispute in this election, particularly in this election petition, particularly because there are pleadings related to what is referred to as vote padding or wrongful aggregation of votes and so on. There are pleadings made in relation to that with exhibits provided. And my lords, I do want to insist, and your lordships can correct me, if he were being led in the witness box in oral evidence, would I not be able to put the case of the first respondent to him? I could.
You could, but the way you have framed the evidence in paragraph 30, whom are you blaming? Mr. Chiketa, look at paragraph 30 carefully. Whom are you blaming?
Whom am I blaming?
Yes, this evidence.
Blaming.
Yeah, blame, B-L-A-M-E.
But
blame.
My lord,
Is it Parliament?
Is it Parliament or the first respondent or the structure that was
my lord, frankly,
established?
Parliament has nothing to do with this.
Yeah, because what he did,
Parliament has nothing to do with it because this is subsidiary legislation.
it was laid before Parliament.
Yes, but I mean, my
It
lord,
was laid before Parliament for 21 days.
My lords, anyway, my lords, I believe that is really not the essence of, because I mean,
It totally is. It's the essence.
So is Parliament responsible for all subsidiary legislation laid before them?
Please. The testimony, as far as I understand it, you are blaming CI 127 on her. Because you are saying that out of 127, CI 127, he had bad motives, and for that matter, votes were aggregated and changed and all that. But that was what the law required her to do.
No, we're saying that the implementation of the law is what occasioned the problems. And that this interposition without good reason was the opportunity for that really error-ridden.
But the problem is with the implementation of the law. Then in essence, the first defendant, the first respondent, did violate the law. But you've not indicated anywhere.
Necessarily, you don't have to violate a law in order to implement it in a way that occasions...
If you don't implement it correctly, as provided in the law,
Then you have violated it.
Well, my lords, we are saying that there was a lack of due process. There was a lack of due process in the implementation. The lack of due process. The lack of due process is certainly an aspect of the implementation of the law. It does not require us to challenge the law or to say that the law itself is the problem. We're saying that in the implementation of a law or of a statute, a piece of subsidiary legislation that she introduced without good reason, we're saying that that was a part of the problem. And we've given a sample of why that occasioned the problems. In paragraph 32, indeed, aggregating the votes, yes, my lords, aggregating the total valid votes as shown by the 275 summary sheet released by the first respondent on his website, the resultant figure is actually 13,200, which is different from the 9. I mean, my lords, how can there be an objection to that passage of evidence? That is a passage of evidence in which reference is being made to the website of the first respondent in order to address figures that she herself, or figures that her first respondent has put forward as a correction of other figures that she read, which we all heard. She put forward those figures. And here, and then subsequent to that, there is published on the website, 275 constituencies. And we do our arithmetic and we say that those figures actually result in this. Not in the figure of the proposed correction. How could that possibly not be, a piece of material evidence from a witness in this election petition, aggregating the total figures. And my lords, this comes directly following paragraph 31 after the 7th December 2020 presidential election. Petitioners, paragraph 31 of the witness statement, petitioners representatives in the strong room discovered that there were errors as a result of which they did not certify the summary of the results from some of the region. They also noticed anomalies with some of the collation sheets that may have been inputted into the results. Based on the observations, the NDC calls a letter and so on. And then indeed, and it follows by talking about what what the first respondent put on the website, which is in contradiction to what she purported to be the correct figures. I mean, my lords, and what is more, those figures are different from
they are not making any case against paragraph 31. Yeah.
Yes,
It's 32. It's 32.
Paragraph 32,
They are not firing with
paragraph
31.
32 is stating quite clearly that the figures that were published by the first respondent on their website, when you put them together, and this again is a matter relevant to the different figures that were being offered by way of correction on the 10th and later. So I think this is a very material, a piece of evidence, especially, my lords, when it is acknowledged that the witness can have put to him the case of the first respondent. The case of the first respondent is that an inadvertent error was made and it was corrected. And the correction itself was subsequently corrected. And we're saying that when you take what is on their own website, this is effectively in the nature of an admission by them that they were wrong even in the purported correction. This is a clearly material piece of evidence, and in paragraph 33, which is the last, I think the last but one, again, this is a statement of that point that the aggregated figures, the aggregated figure from the total valid votes are shown by the 275 summary sheets released by first respondent on his website. This figure is also different from the corrected figure of 10th December in the unsigned press release. So paragraph 32 makes reference to the figures on the website, and then paragraph 33 says that that was also different from the corrected figures. And my lords, with the greatest respect, the issue that is at stake in this petition is the conduct of the first respondent as the returning officer of the presidential election. And that conduct...
Mr. Chikata, which relief relates to the conduct? If we look, which relief? For settlement. You're seeking declaration.
The issue that we've put down, the relief that we have put down is a relief. We have put down a number of reliefs. Now, relief A is that the chairperson was in breach of Article 63(2). Relief B, a declaration based on the data in the declaration made, the data contained in the declaration made by Mrs. Jean Adequate Mensah, chairperson of the first respondent, and the returning officer for the presidential elections held on 7 December. No candidate satisfied the requirement of Article 63. The third relief is a declaration that the purported declaration made on 9th December of the results. Now, I mean, we have set out in the preceding pleadings the basis of our claim of unconstitutionality. We've set them out, including the failures in respect of Article 23 and the failures in respect of Article 296. We set them out. And we're saying that
Thank you.
A declaration that is unconstitutional should be made. And in paragraphs 32 to 33 of the witness statement, we are had, or what the first respondent had put on their website. And with respect, that is clearly a relevant matter. Now, my lords, I have to say that, I mean, these attempts to, take out of our witness statement extremely material matters material matters that relate to the case that is being presented by the first respondent, I mean, are really accepted as part of the witness's witness. Paragraph 37, this conduct of certain officials, and again, my lords, paragraph 37 cannot be read in isolation of the previous paragraph, because when it says this conduct, the meaning of this conduct cannot be read without going back to 36. In 36, because 36 says, Exhibit F is a spreadsheet covering sample details from 26 constituencies showing vote respondent for second respondent as captured on the summary sheets of the respective constituencies. They show that more votes were added to those of second respondent than he had in fact obtained. So this is the conduct that is then referred to at the beginning of 37. This conduct of certain officials of first respondent in padding the votes of first respondent is in fact indicative of a well-hedged and sustained pattern of manufacturing numbers unrelated to the actual votes collated at the various collation centers with the sole aim of achieving the predetermined goal of the chairperson of the first respondent and a number of officials of first respondent to have second respondent unconstitutionally and unlawfully installed as president of Ghana. So this again is evidence that concludes paragraph 36, and paragraph 36 is not being objected to, and it concludes paragraph 36 and indicates that this conduct that is referred to is in fact indicative of a well-hedged and sustained pattern of manufacturing numbers. And my lords, whether indeed numbers were being manufactured or not is obviously a question of fact. It's an issue that is to be resolved by the evidence of the parties and by the determination of which evidence is worthy of acceptance as truthful evidence. And therefore we submit that none of these passages of evidence can be considered as passages that cannot be legitimately within the witness statement of our witness.
With the leave of your lordships, we wish to refer to Order 11 to reply. Yes. Yeah. May I have the lead of the court to reply? My lords, I wish to refer to Order 11, Rule 12.1 of CI 47, which reads, and I quote, subject to Sub-Rule 2, every pleading shall contain the necessary particulars of any claim, defense, or other matter pleaded, including, but without prejudice to the generality of the foregoing words. A. Particulars of any misrepresentation, fraud, breach of trust, willful default, or undue influence on which the party pleading relies. And B, where a party pleading alleges any condition of the mind of any person, whether of any disorder or disability of mind, or malice, or any malice, fraudulent intention or other condition of the mind, except knowledge of particulars of fact on which the party relies. My Lord,
Mr. Utuampa, what you've just
impacts of COVID-19 on children and women in Ghana detailed how COVID-19 impacted on the lives of women and children in the country. Mr. Speaker, below are some of the findings contained in the report. More than half of the children covered by the survey live in households whose principal stopped working for COVID-19 reasons. 79% of the children face a reduction in total household income compared to March 16, 2020. 24.1% of the children aged 6 months to 14 years had fewer meals than usual in the 4 weeks before the survey. 44.2% of the households with children aged between 6 to 14 years have stopped receiving meals from school feeding programs since school closures. There is limited use of healthcare services. More than 35% of the households with children sick in the 7 days before the survey sought medical treatments from pharmacies and chemical drugstores. Mr. Speaker, for fears of COVID-19, infections are the main reason for COVID-19 infections are the main reason for not making antenatal care visits to health facilities, nor vaccinating children as per schedule, followed by income and mobility restrictions. A high percentage of children have presented emotional changes, with up to 30.4% of the households reporting having children aged between 6 to 17 years who felt sad more often. Nearly half, about 45.6%, of the children born since March 16, 2020, have no birth certificate, no registration with civil authorities. Mr. Speaker, child labor has increased among children between 5 to 17 years old, especially for household chores, 34.8%. More than 1/5 of the children live in households in which physical punishment has become common, 20.9%, with no gender difference. Mr. Speaker, a significant number of children normally attending primary and junior high school, that's about 34.8%, or senior high school, about 28.1%, have not engaged in any education or learning activities since school closures. Almost every household is aware of preventive hygiene measures to reduce the risk of contracting COVID-19. However, 21.7% of the children live in households without regular access to water supply, and 17.7% without regular collection of solid waste. Mr. Speaker, it can be seen that most of all the statistics contained in the report above did not go in favor of women and children since the inception of this pandemic. Mr. Speaker, in recent times, violence against women and children has increased, and if care is not taken, may generate into another pandemic that the country might not be able to handle. Mr. Speaker, school children are one of the groups that are most vulnerable in this time of COVID-19. With the opening of schools, much is needed to have been done to ensure their safety. Hence, the provision of PPEs is key, even before the enforcement of schools reopening. More than 2 weeks after resumption, most people have been seen without face masks, hand sanitizers, while most of the schools do not have Veronica buckets of water for the pupils to use due to the lack of potable water. Schools with Veronica buckets do not have water in them, so they are just white elephants. Mr. Speaker, I will suggest that the President should take it up as part of the stimulus package to drill boreholes in all schools, especially those in the rural communities. And this will not only serve as a source of water for washing of hands, but for drinking by both peoples and community members. Mr. Speaker, a pandemic such as COVID-19 has not only taken a toll on women, but also brought out the creativity in them. Since the inception of COVID-19, women have played many important roles in ensuring that the virus is brought under control by creating quality health hygienic products needed in their communities. On realizing the lack of PPEs, women were very creative in producing face masks, hand sanitizers, hand washing soap, etc., as their contribution in fighting this COVID-19, but they do not have the resources to continue in this direction. Mr. Speaker, I would like to conclude by calling on governments and civil society organizations to come out and support women in this heightened COVID-19 season so they can produce products that may that may help the community members and can use protect themselves and also earn a steady income out of it. Mr. Speaker, if this is done, I believe it will go a long way in reducing the violence against women in our communities. I thank you, Mr. Speaker, for the opportunity.
Honourable members, since the three statements are on the same subject, I want us to take all the three, and then members will be invited to make their comments. So the second statement stands in the name of the Honourable Member for North Tong, Honourable Samuel Okujeto Ablakwa. Honourable Member, you may make your statement now.
Right, Honourable Speaker, I'm grateful to you for the opportunity to make this statement on what is undoubtedly of considerable public importance, particularly to the Ghanaian traveling public. Ghana's COVID-19 antigen test, which cost a whopping $150 United States at the Kotoka International Airport, remains one of the most expensive, if not the most expensive airport COVID-19 antigen test anywhere in the world. This amount, which is punitive and retrogressive, is leading to widespread agitation and incessant appeals from the general public for an urgent intervention, especially by this August House. Mr. Speaker, there is hardly a day passing without our constituents, Ghanaians in the diaspora, and members of the general public reaching out to us on the cutthroat cost, which they consider to be most unbearable, a view I strongly share and identify with. The public outrage has continued to play out on many media outlets. Mr. Speaker, in the wake of the current COVID-19 pandemic, one of the vital tools for risk minimization and to slow down spread of the virus has been the testing and isolation of infected people. According to the World Health Organization, the surest way to overcome this pandemic is to test, trace, and isolate. At the peak of the first wave, most countries closed their borders to ensure that infections were not introduced through travel. It soon became apparent that if steps were not taken for countries to be opened up, the aviation and tourism industries were going to be badly damaged, though other sectors of the global economy were not going to be left out too. Most countries therefore came up with a requirement for travelers to obtain a negative polymerase chain reaction PCR test for SARS-CoV-2 72 hours before they could board flights. As further scientific evidence emerged, it became clear that PCR by itself was not robust enough, because the procedure can take up to 24 hours for results to be produced. Passengers need to be given up to 72 hours to get the test done, and there is potential for new infections to occur or previously undetectable infections to show up in the time lag between testing and traveling. Following the development of newer, more rapid tests, countries including Ghana reviewed their protocols to ensure that an antigen test was undertaken on arrival. This was to ensure that any latent infections that were missed by the earlier PCR test were identified and isolated. Being more sensitive and elaborate, the PCR test must be run within a laboratory setting for 6 hours or more, with expensive equipment and requisite human resources. This makes it relatively more expensive than any of the other forms of COVID tests available.
First Deputy Speaker to take the chair. Please, you may continue.
This makes it relatively more expensive than any of the other forms of COVID tests available. At the start of the pandemic, the average cost of PCR was between $60 and $100. This has continued to drop, with the current cost ranging between $16 and $100. Mr. Speaker, the antigen test, which is what is sanctioned by the Akufo-Addo administration at the Kotoka International Airport, However, it's a point-of-care test that is simple to administer according to the experts. They indicate that it relies on a fluorescent device or a simple cartridge, like a home pregnancy test kit, and is priced at between $4.58 and $12 on the international market. At the time when Ghana reopened its borders on the 1st of September 2020 and introduced the requirement for antigen testing, the stated price at the airport of $150 was justifiably considered by many who know that this technology is less sensitive and cheaper than PCR as expensive. However, government officials mounted a spirited defense and have since September last year maintained the $150 charge per traveler. Mr. Speaker, it is instructive to note that my research reveals that other countries run the antigen test at a far cheaper cost than Ghana. Respectfully, with your indulgence, a few examples will suffice. Malawi charges $25. Malaysia charges $28. India at the Goa airport charges $28. India at the Via Savarkar International Airport charges $7. The United Kingdom at the Heathrow Airport in London charges $70. Mr. Speaker, what is even more striking is the realization that the overwhelming majority of countries with the more superior PCR tests at their airports have charges that are shockingly far cheaper than Ghana's inferior antigen test cost. A few references. Togo charges $80 per PCR test. Sierra Leone charges $80. Senegal charges $75. Rwanda charges $60. Djibouti charges $28. Germany charges $70. And Turkey has only a $16 charge for a PCR test. Mr. Speaker, at the 58th ordinary session of the Authority of Heads of State and Government of ECOWAS, held on the 23rd of January 2021, and chaired by our President, His Excellency Nana Addo Dankwa Akufo-Addo, the performance of member states in the pandemic fight was reviewed. During this review, the harmonization of cross-border movements of persons and goods was approved. As part of this approval, it was agreed that PCR testing for travel within the sub-region will be capped at a maximum of $50 United States dollars. With this new development, Mr. Speaker, it is my considered view that the $150 per cost of antigen testing at Kotoka International Airport has become even more untenable. It cannot be right that the cost of antigen testing will be 3 times more expensive than the cost of the more sensitive and superior PCR test. I further submit, Mr. Speaker, that a look at the average wholesale cost of antigen tests on the biomedical science market is between $4.58 and $12. One may wonder how the cost to the end user will be approximately 12 times the wholesale cost should the upper value of this range be used. Mr. Speaker, on the 21st of January 2021, the Kingdom of Netherlands indicated that with effect from midnight of the 23rd of January 2021, travelers to that country will require an antigen test in addition to the 72-hour PCR test performed within 4 hours of boarding a flight to that country. Being a member of the Schengen area and European Union, it is likely that other countries in this group will introduce similar requirements. Air France has already done that. Documents available to me indicate that the company operating the testing regime at Kotoka will be undertaking this test too at the same cost of $150 United States dollars, which works out in terms of current exchange to 850 Ghana cedis. According to a notice by the airline KLM, travelers can opt to take the antigen test at Akai House Clinic on 6 Circular Road in Cantonments for 250 Ghana cedis. The question is, Mr. Speaker, why maintain this punitive $150, which works out to some 850 cedis, when the test can be run at much lower cost elsewhere, as we have seen being carried out at Akai House? And why is the antigen test not being made more widely available? Mr. Speaker, this, if not checked, could make travel to Ghana less attractive in this era of global economic downturn. As apart from the routine airline travel cost, passengers will require an average of $350 to $600 per person, depending on where the tests are carried out, for COVID-19 testing, just to make a return journey to Ghana. For a family of 5, this would translate to some $1,750 to $3,000 just for COVID tests alone. Mr. Speaker, reports are also emerging about how some travelers are forced to collude with officials at the airport in order to beat the system due to the exorbitant charges. The Ghana Medical Association has had cause in a recent statement to draw attention to loopholes at the airport because of this phenomenon, which is leading to further importation and spread of COVID-19. This is therefore rendering the entire port counterproductive and clearly putting all Ghanaians at high risk as our case numbers continue to rise sharply. Mr. Speaker, equally troubling is a regrettable fact that this $150 exorbitant charge was not brought to this House for consideration and approval as the Fees and Charges Miscellaneous Provision 2018 Act 983 demands. There are also fundamental concerns about the lack of transparency and alleged breach of due process, not limited to flagrant violations of the Health Institutions and Facilities Act 2011, Act 829, when a new Frontiers Healthcare Services was awarded a contract to carry out these antigen tests. Frontiers Healthcare Services is said to be beneficially controlled from the tax haven of the island of Dominica. Civil society organizations such as Imani have publicly raised alarm about these rather opaque arrangements. Mr. Speaker, I believe the time has come for this House to carry out its constitutional mandate of oversight by investigating all these matters as a matter of urgency. It is also absolutely imperative that we initiate concrete steps to cause a drastic reduction of Ghana's antigen test cost to align with international best practice. The punitive and retrogressive cost is greatly undermining the fight against COVID-19. May it not be said that this House sat idle by, as a few appear to engage in supernormal profiteering at a time when many lives are being lost to this global health crisis. Mr. Speaker, the government has also amended its original program of offering free COVID tests except in very limited circumstances of walk-in requests based on ill health, contact tracing, and exposure. Thus, according to a 27 January 2021 directive from the Ministry of Health, signed by Acting Chief Director Kwabena Buedu Oku Afari. And so, Mr. Speaker, virtually all the positive tests we are recording now are due to people who pay between 300 and 600 Ghana cedis to get tests done. We are thus missing a broad swath of Ghanaians who cannot afford the tests. And so we cannot get a handle of the problem until we can measure it. Unless antigen tests, which are cheaper and faster, are deployed widely across the country and made free in most cases to measure the scale of COVID in Ghana, we will be groping in the dark, for it is trite that what doesn't get measured doesn't get managed. Finally, Mr. Speaker, it is my fervent hope that the executive will be more audacious and ingenious, including deploying the use of advanced skillful diplomatic negotiations in securing vaccines much sooner than the 6-month timetable earlier advertised, as other African countries such as Seychelles have been able to achieve. The international community must understand that we first and not me first is the only solution to this pandemic. I convey deepest condolences to all those grieving on the loss of loved ones and wish all infected a speedy recovery. May we all continue to do our bit in a determined quest to defeat this ravaging virus. I'm most grateful to you, Mr. Speaker.
Advisor, there's a third statement by the Honorable Deputy Whip, Lydia Sarah Molassen.
Thank you, Mr. Speaker, for the opportunity. COVID-19 nationalism and its impacts on Ghana. Mr. Speaker, in accordance with Order 2072, I rise to bring to the attention of the House an important matter of public health concern whose implications will be dire, barring strategies to handle it. The matter, Mr. Speaker, has to do with COVID-19 nationalism and its implications for Ghana. I must quickly add, it is a matter that Honorable Okudzeto Ablakwa touched on briefly the other day in his contributory remarks. Ever since COVID-19 pandemic ravaged the globe with its devastating health and socio-economic effects, there has been frantic global effort to produce a vaccine capable of providing immunity for humanity. Thankfully, Mr. Speaker, despite the emergence of a new variant of COVID-19 or SARS-CoV-2 virus that has sparked a second wave in many countries, including Ghana, some headways have been made. Recent announcements by pharmaceutical giants such as Moderna, Pfizer, AstraZeneca, and Gamaleya Institute of Russia on the mass production of the vaccines. We have a renewed hope of a possible earlier than anticipated conquest of the virus and a return of public life to normalcy in the shortest possible time. Mr. Speaker, it is important to state that it takes an average of 10 years for a vaccine to be developed, but the global scientific community successfully developed the COVID-19 vaccines in a record time of 332 days. This genetic sequence of the vaccine's virus was published. This remarkable achievement was only possible due to the extraordinary collaboration of unseen proportions among governments and scientists all over the world. While those groundbreaking developments represent a major step toward overcoming the pandemic, the unprecedented global race for the vaccines has resulted in vaccine nationalism and vaccine hoarding, which bear the potential to spell doom for countries in the developing world, including Ghana, who lack the economic muscle to compete with those in the global north for the vaccines. Mr. Speaker, the World Health Organization has already warned that Africa is in danger of being left behind in the rollout of COVID-19 vaccines as countries in other regions strike bilateral deals to drive prices up. It's also instructive to note that so far, Guinea is the only low-income country in Africa that has received doses of the vaccines, with only 55 people inoculated so far. Seychelles and Egypt remains the only African countries who have started a nationwide vaccination campaign. Clearly, Mr. Speaker, this paints a gloomy picture of Africans' recovery from the pandemic. Notwithstanding the discovery of vaccines. This underscores the need for Ghana in particular to develop a comprehensive COVID-19 access and distribution strategies, which, among others, would ensure that 1. Collaboration with development partners in other African countries, both at the sub-regional and continental levels, for timely access to the vaccines. 2. An establishment of mechanism that ensures fair pricing and a resolution of monopolistic tendencies among local importers and wholesalers to avert unwarranted inflation of prices in the country. 3. A fair and equitable distribution which prioritizes hardest hit areas and vulnerable groups. And 4. The design of public education and sensitization programs to effectively deal with conspiracy theories which will lower public acceptance of the vaccines. Mr. Speaker, having said this, let me use to commend His Excellency Nana Addo Dankwa Akufo-Addo, the Ministry of Health, Ghana Health Service, and the Ghana COVID-19 team for the proactive steps taken so far to ensure early procurement and receipt of the newly developed vaccines by the end of June this year. I am also informed that a technical committee has been instituted to oversee the rollout of the first batch of the vaccines. I remain highly confident, Mr. Speaker, that these measures, coupled with the development of a comprehensive COVID-19 access and distribution strategy that factors in the aforementioned recommendations, would enable Ghana overcome the pandemic. I am grateful once again, Mr. Speaker, for the opportunity.
Honourable members, I'll now admit comments from members on the floor. Yes. Now I can't identify you by your faces, but actually intended the honourable member in a smoke.
Thank you. Thank you, Right Honourable Speaker. Right Honourable Speaker, it is Clement Apak.
Oh, okay.
Member of Parliament.
I think we would continue in that tradition. You identify yourself so that members can follow your discussion, knowing who you are.
Member of Parliament for Busa South, and your junior vandal from the Great Commonwealth Hall. Mr. Speaker, I rise to commend all colleagues who have made very valuable and insightful statements today on various aspects of COVID-19. But in particular, I wish to contribute to the statement made by the Honorable Ladi Ayamba. Mr. Speaker, she has been very candid, straightforward. Certain schools have received Veronica buckets, nose mask, and don't have sanitizers and or liquid soap. So, Mr. Speaker, the situation is very worrying. If indeed we saw it fit to reopen schools after 10 months of closing them down because of the fear of COVID-19, why would we have gone on to reopen schools without first making sure that the bare and basic necessities would have been on site at the schools before students reported? So although the Director General of the Ghana Education Service yesterday, whilst taking his stand at the bi-weekly coronavirus update series at the Ministry of Information, indicated the supplies that had been made available in their tens of thousands, the truth is that that is after the fact. And the truth is that as we speak, those supplies are yet to get to several schools in this country. I would have wished that the Director General of GAS, the good old professor, would have gone on to even give us a breakdown as per the quantities of supplies sent to each region, sent to each district, to allow us to be able to report back accurately as to whether perhaps, in spite of his own effort, other subordinates who were expected to ensure that the PPEs got to the schools have been sleeping on their jobs. But as we speak now, in all honesty, there is a need, if I may suggest, for teams to be put together to monitor and report back so that we can be sure that all the monies being spent and the quantities of PPEs that the Director General indicated in their tens of thousands as having been distributed have indeed gotten to where we expect them to be. Mr. Speaker, the other issue of concern, and as far as COVID-19 and our children goes, is this. Several of our public schools are overcrowded. We have heard reports of an introduction or reintroduction of the shift system. But how effective that has been is yet to be ascertained. As we speak, we have reports of classrooms hosting in excess of 80 students. Truly, how do we expect there to be physical and social distancing in a classroom that is hosting 80 students? Clearly, we cannot expect our wards, as young as they are and as confused as they may be, to be able to abide by the protocols when we do not create the requisite environment for them to do so. In addition to that, there are instances where the classroom sizes may not be that big, but as a result of a lack of adequate furniture, you have students clustering on dual desks, which traditionally are designed to seat 2 students. You have 4 students sitting on a dual desk. How truly do we expect the students to be able to abide by physical and social distancing? It is my candid opinion that since we are not in usual times, we could look beyond just the introduction of the shift system. There is no reason why, as we have done as members of Parliament, having left our chamber for the sake of safety and for the fact that we seem a bit more crowded in there, to this extent, there is no reason why that cannot be replicated in the schools that have higher populations. After all, in difficult times, when catastrophes hit, refugees are provided with tents. Here we are in a tent. So may I humbly suggest that government and the GES should consider erecting tents in those schools where the students are many, and to provide furniture so that our wards can also be safe. Hitherto, we had the impression that by virtue of the robust immunity of our kids, they could resist or withstand the virus. Only yesterday, reports from the Konfanochi Teaching Hospital indicate very clearly that that is no longer the case. Children as young as 11 days old, 14 years old, are on record to have contracted the coronavirus. Mr. Speaker, if there was ever a time for us to expend our resources in the interest of Ghanaian citizens, this is the time. Thank you for the opportunity.
Honourable Member of Fijase Asokore.
Mr. Speaker, I rise to comment on these statements ably submitted and presented by members of this august House. Mr. Speaker, it touched on various areas. In terms of the effect of COVID on schools, it was revealing for the honorable member on the other side to state the effect of closures of schools on feeding, and that presupposes that about 24% of children who couldn't access school feeding opportunities during the period of closure indeed would suffer some level of malnutrition. So consequently, the closure of schools imperiled the nutritional level of some children in various parts of the country. Sad as it was, those actions, I guess, was absolutely necessary to have been taken. It is indeed gratifying that we have the students coming back and schools have been opened. In that regard, one would expect that arrangements in terms of feeding will be adequate, available, and unconditionally accessible by all these children. Where we should also condemn most is violence that was meted to women and children during this period. But for child labor and also other reasons, you are worried to know that from the report, during this period, such persons we consider vulnerable as those women and children were subjected to some level of abuse. Mr. Speaker, with your indulgence, I crave that you would want to get the appropriate institutions to give us any statistics whatsoever and what they have done about persons who subjected loved ones to such torture. For the issue to do with schools reopened, and some of the Veronica buckets don't have water in them, it is also a source of concern because we all know the consequent effect, spread of diseases through waterborne illnesses. I am aware that through the measures of government trying to make water available in communities for free, some MCAs and DCAs manage to get water in various rural parts of the country. And for that matter, for schools in those communities, they can access them. And I think that assemblies have the august responsibility to make sure that schools have water adequately stored and available for kids during school reopening. Indeed, it is also worrying if the assertion is true and confirmed that some buckets find themselves without water. I was looking forward to the Honorable Robert to have made an example, but I think that yes, she can find, or Mr. Speaker, you can find a way to grant ahead a hearing to make mention of some places, probably after closure. So adequate steps can be taken, and kids should access water, which is mandatory. But to talk about the issue with antigen testing at airport, Mr. Speaker, we will commend government at first hand, because at the time that they introduced antigen testing at the airports in September, many countries have not started, and therefore Ghana stood to be pace setters, especially as it was the first week of September. By and large, several other countries joined, and that is to say, we had a visionary president, a very able task force, solid ministry who were supportive and brought the idea for testing. Indeed, persons have tested in their countries with PCR, but they arrived with positive cases identified amongst them. Also is the issue of certification. Because of the absence of a unified platform, persons, I'm sure, are finding themselves to present all manner of certificates. And that undoubtedly would allow people to get access into the country or even out of the country, probably haven't tested for COVID, but then it will show they are negative. And the absage clearly shows that there is some level of inefficiency, and I would think, to add to the position of my colleague, there's a need for a unified certification as urgent as it should be, whether you are going out or you are coming in. But to do with the issue of pricing, and as much as I commend the government for this innovation, I would say that your committee did not have the opportunity to meet stakeholders to find out the reasons for the costing. And as a health economist, I would not delve into saying or hurriedly to say that it is expensive unless when your committee has a chance to meet stakeholders. Mr. Speaker, in as much as you are in a hurry to set up your committees, I know that when your committees are established, your able committee of health, which you have able men and women who do a very good job, will definitely invite all stakeholders and present appropriate report to do with the cost centers and while they arrive at $150. But that is to say, I will still stand and commend my colleague for recognizing the feeling of some persons and their concerns. But then, given opportunity by you, your committee will do that job and we can advise appropriately. With vaccines, the good president of this country on his briefing told us that they are trying to source the COVAX facility, which is a WHO Gavi, that will allow for participating countries to benefit from 20% of doses correlated to their population size. So to say Ghana having a population of 30 million, we probably stand to enjoy about 6 million doses. And that will come at the end of the first quarter. That will make available doses for frontline workers and other essential people and also vulnerable people in the communities. I would say that we have to be firm and believing in the assurances of the president, who has been on top of the management of COVID, who has been cited so much in various countries. And as much as he has spoken, it will be delivered. And so we're looking forward to the end of first quarter to have the doses as such. So, Mr. Speaker, before I take leave of this position in my expose, I would still take the chance to thank the makers of the statement. It is brilliant, absolutely brilliant. And thank you so very much, Mr. Speaker.
Thank you, Mr. Speaker, for the opportunity to add my voice to the three statements made by my colleagues and especially on the statement made by my senior colleague and mother, Hajia, Honorable Hajia Ladi, on women and children. In adding my voice, Mr. Speaker, I must say that the COVID-19 pandemic has brought a lot of hardship onto women, as stated in Hajia's statement. Today, women have the responsibility to provide PPEs for children. And as we are all aware, children, as they play around, some of them end up throwing their PPEs away, their nose masks away, they might misplace it, and the mother will have to go and look for a new one. That costs a lot of money to that rural mother. Mr. Speaker, there is no contact tracing specially available for children and their mothers. Mothers, some of them are able to fend for their family by selling in the markets that are already choked or crowded. So there must be a way to trace those who are infected and then those who are not infected. There must be a special program for women and children in this very critical time. Mr. Speaker, there is also a very serious thing that we have to look at. The children that are supposed to go back to school and the teachers, what are the special arrangements for them? Is it just going to be providing nose masks and that will be all? Or there will be health professionals in the schools who will be guiding and helping the teachers to really provide care in a way for these children? Mr. Speaker, if we fail as a country to do or to provide our women and children special opportunities for this pandemic, we will end up having a lot of cases in the country. Mr. Speaker, I know you talk for us. I know you are interested in our matters. I mean women and children. Please, the committee that my colleague just spoke about, I would like to add my voice to or support what he has said. That, Mr. Speaker, set the committee up, add women to the committee, and let's talk about ourselves. On that note, I thank you so much, Mr. Speaker, for the opportunity.
Yes, member.
Thank you, Honorable Speaker. Kingsley Nyako from Kwadaso constituency. Mr. Speaker, it is true that COVID is ravaging our homes, our families, and our societies. In my respected view, the government and the president have done so well by putting in interventions to deal with this unfortunate pandemic. My observation has been to the fact that our attempts in addressing this pandemic have zeroed in mostly on behavioral measures like washing of hands, wearing nose masks, sanitizing our hands, and all that. These are psychological variables that are very important. But there are other psychological interventions that it seems we've not averted our minds to. For example, stigmatization. And that is due to
the fear and anxiety persons who suspect of having this disease don't want to engage in, because they are afraid that when it comes out that they have COVID, they will be stigmatized. That prevents most people from going for testing, and that is worrying. This same stigmatization makes some persons engage in unacceptable practices, resulting to unorthodox ways of dealing with this disease that can in fact have egregious consequences on their being, and that will be also to the cause of the nation. So I hope that our education intervention should also look at some of these variables that can help us to contain or deal with the COVID-19 pandemic. Mr. Speaker, one other point I also want to make is about post-traumatic stress disorder. This is one's inability to recover from an unpalatable experience or event. And this has very negative effects on persons, especially children, who saw the demise of persons who are very close to them. My question is, what have you put in place to ensure that children and young adults who have experienced the demise of somebody affected with this pandemic to cope? It's very important, because if that is not done, it can disrupt their thinking patterns that will prevent them from pursuing their education, study and all that. So as much as I commend the President and the government for the good work done, I'm also trying to plead that we avert our minds to not only the outward behavioral practices, but also some cognitive practices that will help us to deal with this particular pandemic. COVID-19, some people say is a blessing, others say it's a curse. Whichever way you look at it, curse because it has caused a lot of havoc to society. Blessing maybe gives us the opportunity to do something new. It's a new normal. We have to live with it. But you have also understand that it gives us the opportunity to do things anew, things that will help the collective progress and development of this country. On that score, Mr. Speaker, I humbly thank you for the space given me. Thank you.
Doctor, yes.
Thank you, Mr. Speaker, for giving me this opportunity. I want to thank the makers of these statements on COVID-19 and have this to say. The current conditions that we are living in, especially after the elections, is worse than before. When I say worse than before, I'm comparing it to the COVID conditions before elections. Yet we are walking that tightrope of living a normal life. And that is why we've got to make the decisions to have our children at school, recreation, football, etc. is still going on. And of course, the sitting of Parliament and industry is still working. However, Mr. Speaker, the conditions have changed. I'm saying this because currently, if I had it right, you can walk to any public health laboratory and have the COVID test carried out. Then the golden question we've got to ask ourselves is, why are we still charging $150 at the airport? My colleague came to paint a picture as if things are not good, things are still worse. But why should we still pay 150 if the ordinary Ghanaian can walk to a public health facility and have the test? We should remember that those arriving from abroad, majority of them are our brothers, our children, our own people. I don't know who we are exploiting, but if you buy your own tank and think that you're chewing it, you've done practically nothing. Mr. Speaker, the other thing I want to comment on is the vaccine. I've heard that there's a timetable for us to have the vaccine in 6 months' time. And my good colleague, Deputy Chairman of the Health Committee, also mentioned. Mentioned that there's an international plan to supply 20% of the population, and he estimated it at 6 million. But we've gotten to a stage where we've got to take our own destiny into our own hands. There are problems with this international supplies, etc. AstraZeneca is not meeting the European Union demands. A lot of countries are making their own effort, and even a country such as what? Guinea. I'm saying so because we know that Guinea, comparative to us, we're not even behind them, Mr. Speaker. They are making an effort, even though the number is small. Mr. Speaker, we have to take our destiny into our own hands. The 6 months is too much. It's far away. I am calling for vaccines now. Thank you, Mr. Speaker.
Vaccines now. Vaccines now.
Yes, Honourable Member. Yes, Dr. Free is right.
Thank you very much for the
Dr. Efrie Kwaku
Serioso,
yes.
MP for Serioso. Mr. Speaker, thank you very much for the opportunity, and I thank the various makers of the statements for bringing this problem to the fore of Parliament. Mr. Speaker, I think they've covered a wide area, the social aspect of it, even the vaccine prevention aspect, and even the sociology with regards to children as is playing out there. Mr. Speaker, we are in difficult times, and we do not have a handle on all the parameters. Indeed, some of the problems seem even paradoxical. Let me give you an example. When schools were opened previously for, I think, those who were bound to do examination, there was a hue and cry in this country when there were sporadic outbreaks in several places. Turned out that in the final analysis, schools turned out to be the most secure places to have your children in. But now we are in a new vista, and we have scaled up the, as it were, the children going up back to school. And there are toddlers amongst them who cannot be trusted to observe all the protocols. Mr. Speaker, in spite of all that is happening, I think we have to get our perspective right and not get into panic mode. Yes, we have a clear incidence of rising infection, but we are not in the European and American proportions yet. And I'm not suggesting that we should reach there before we take action. Mr. Speaker, we have some knowledge as to what we should do. I want people that if we decide as a nation go into reset mode, and even with the tools and knowledge that we have, we can, in double quick time, we can bring the numbers down. I'm not even suggesting that we should have we should go into a lockdown. But conceptually,
if you are not close to anybody, you cannot get the infection. If you imagine that you live on an island and you are not close to a neighbor, you cannot get infection. If willy-nilly you have to be close to somebody, then it means you have to adopt all the barrier measures that you can master, so that if the assumption is that he or she has the infection, it cannot be transmitted to you. That knowledge should go to the people, and we should make sure that everybody understands that, so that even if we are having funerals, people might not take risk. Mr. Speaker, I'm suggesting that a lot of people have not digested this knowledge, and they have some woolly knowledge about even the transmission of COVID. If we give that kind of knowledge to people, I'm sure that they can take care of themselves. Mr. Speaker, if you look at the geographical distribution of COVID, you see that it is an urban phenomenon, even though there are sporadic cases in the rural settings. So that our approach should be that those areas that COVID has not touched, we should maintain them while we take care to deal with the situation in urban settings such as Accra and Kumasi and elsewhere. Mr. Speaker, even in Accra, it is very strange that places like Choko, Kolegono, and others, for some strange reason, those people are packed together, and yet there's minimal spread. It is because of the outdoor life. Here, we are saying that we are maintaining social distancing, but we are living in an enclosed capsule. And I'm suggesting that that empirical thought, that because we have social distanced ourselves and yet we have encased ourselves in this kind of casing, might not exactly be good for us. In this sense, I recommend that we should even, as far as school children are concerned, that concept that we jettisoned, school under trees, we are in the dry season. I'm suggesting that as far as possible, schools should be organized under trees now, because the body of empirical evidence suggests that when you stay in non-enclosed spaces, you don't get infected. That knowledge must be put to good use. That's why it's a better place than those in temperate climates who are in winter time. Vaccine nationalism. It's a phenomenon that has always been around for a long time. As far as medicines are concerned, I'm suggesting that as far as in this world, neglected tropical disease, malaria, ulcer, tuberculosis, the largest disease of tuberculosis,
Those are from the
Now, the 2020 December 7 elections was conducted under rules passed by Parliament. Is that correct? The 2020 December 7 elections were passed was conducted by rules passed by Parliament. Is that correct?
That's correct. My Lord, it is supposed to be to be conducted by the rules, but we have issues about the application of the rules in the conduct of the elections.
CI 127 is binding on the petition. That's well, it was expanded. Sorry. The petitioner appointed agents for each of the polling stations in the country. Is that correct?
That's correct, my Lord.
How many agents did the petitioner appoint for each polling station?
2 agents.
Now, at each polling station, the petitioner and indeed all the other candidates had agents. Is that correct?
I cannot speak for all other candidates.
Now, you trained your agents on what their duties at the polling stations would be.
Yes, my Lord, that's correct.
You trained your agents on how Forms 8A and 8B was to be completed in each of the polling stations.
That's correct, my Lord.
You trained your agents on how each form was self-auditing, and
that's correct, my Lord.
You also trained them that if they stated the reasons for not signing, the issue will be taken up at the constituency collation centers. Is that correct?
That's correct, my Lord.
You also trained your agents that at the end of counting and entering of figures, stations will be noted on Form 8B for resolution at the constituency collation centers. Is that correct? Train them to cross-check their Form 8Bs with anything that is done at the constituency collation center. Is that issues with Form 10? They could refuse to sign it and state the reasons therefore. Is that correct?
That's correct.
Answers, your agents had the Form 10s with them.
You assumed.
Yes.
Now, whether that is the case is another matter.
Now, you also agree with me that with our elections, results are declared at all the polling stations before they move on to the constituency. Once the results are counted, they are declared at the polling station before we move on to the constituency centers.
Yes, my lord, unless there is a challenge about a particular polling station results.
Yes. And at the constituency level, the collated results are put together, and then a winner of a particular constituency is declared. Is that correct?
We have two elections at the constituency that are collated at the constituency level. I don't know which one. Is that the presidential or parliamentary?
Sir, you are here because of the presidential election. Is that correct?
Yeah.
My question is in reference to the presidential election.
The declaration is not done at the constituency level. They indicate the tally for each candidate. The presidential election results are declared at the national level by the returning officer.
Are you therefore saying that at the constituency level, your agents do not know who has this number of valid votes at the constituency level?
That's what I'm calling the tally. The tally of the votes are known, but that is not the declaration of the presidential election.
Okay, good. You train your agents that the Form 10s will be transmitted to the regional coalition centers. Is that correct?
That's correct, my lord.
Now you also appointed agents to each regional coalition center. Is that correct?
That's correct, my lord.
Indeed, some of your agents, as announced publicly, were lawyers. Is that correct?
That's correct, my lord.
Now, you also trained your agents that all the information on Form 10s will be collated into Form 11. Is that correct?
That's correct, my lord.
You also trained them that from collating the results on Form 11, the results will be entered on Form 12. Is that correct?
That's correct, my lord.
Now, you also trained them that at that point, they would be invited to either sign onto the Form 12 or object. Is that correct?
That's correct, but they are involved, so they are not sitting somebody to be invited to sign. They are involved in the collation, and if they agree that the process has been proper, they are invited to sign.
Okay. Now, are you aware that of the 16 regional coalition forms, your agent signed 13 of them?
Yes, my lord.
Are you also aware that one of such forms that was signed was in reference to the Ashanti region? Is that correct? One of the forms that your agent signed, it was in reference to the Ashanti region?
Yes, my lord.
Your agent signed the form for Ahafu. Is that correct?
That's correct, my lord.
Your agent signed the form for Oti. Is that correct?
That's correct, my lord.
Your agent signed the form for Northeast. Is that correct?
That's correct, my lord.
Your agent signed the form for Bono. Is that correct?
That's correct, my lord.
Your agent signed the form for Upper West. Is that correct?
That's correct, my lord.
Your agent signed the form for Upper East. Is that correct?
That's correct, my lord.
Your agent signed the form for Central Region. Is that correct?
That's correct, my lord.
Your agent signed the form for Western. Is that correct?
That's correct, my lord.
Your agent signed the form for Savannah. Is that correct?
That's correct, my lord.
Your agent signed the form for Volta. Is that correct?
That's correct, my lord.
And your agent signed the form for Bono East. Is that correct? Bono East. It was signed by Ali Mohammed Samsudeen.
That's correct, my lord.
Good. Now, on each of those forms, your agents signed to declare as follows. We, the undersigned, do hereby declare that the results shown above are true and accurate account of the ballots in the region. Is that correct?
That's correct.
Now, at the National Collation Center, which is the headquarters of the first respondent, you appointed 2 persons to that place for the collation. Is that correct?
That's correct.
One of such persons is Rojo Metonunu. Is that correct?
Yes, my lord.
And Mr. Rojo Metonunu has been a former deputy minister before.
That's correct.
And Mr. Rojo Metonunu has been involved in elections and has even litigated 2 cases in these courts. Is that correct?
My lord, I can't testify to the fact about his litigations, but I know he has been involved in our elections.
Now, there's a reported case. Okay, right. Now, are you aware that at the National Collation Center, Mr. Rojo Metonunu certified 12 of the 13 forms signed by your representatives?
My lord, I cannot testify or deny, but the other agent who will be present in court to testify as to what happened in the National Collation Center, my lord.
Right. Now, let us go to your witness statement. You spoke about Exhibit D, the letter from the National Democratic Congress.
Yes, ma'am.
Dated 9 December 2012. I suggest you that that letter was not delivered to the first respondent.
My lord, our agent who was in the headquarters of the first respondent will be present in court and will attest to that fact.
So you do not know whether it was submitted or not?
A report was made back to me that it was submitted.
I am putting it to you that that letter was not submitted to the first respondent. Yes. I am putting it to you that that letter was not submitted to the first respondent.
My lord, that fact will be confirmed or denied by the agent who will be in the box subsequently.
So you are telling this court that you do not have personal knowledge of whether or not the letter was submitted to the first respondent?
My lord, I indicated that I had a report, a feedback that it had been submitted, and since I wasn't present there, I cannot see it as a matter of something that has come to my knowledge.
Right. Now, let's go to your letter. Your letter is in 2 parts. Is that correct? You can look at it.
You have it.
It is marked Exhibit D. Yeah. Would you be kind enough to tell the court the person who signed this letter?
My Lord, it was signed by my deputy on my behalf.
What's the name of the person?
Peter Boama Otokuno.
Right. Now you agree with me that the portion marked C talks about parliamentary elections and therefore has nothing to do with the petition in this court.
Yes, my Lord.
You also agree with me that despite all that you've written about Ashanti, Ashanti was signed by a gentleman called Broja Jemfi. Do you know him?
Yes, my Lord.
And I'm further putting it to you that Ashanti was certified by Mr. Rodu Metonunu.
My Lord, the agents who will come subsequently will be able to confirm that or deny it.
Do you know whether Rodu signed or not?
Please, I'd like to take the question again.
I'm asking you whether you know that when Ashanti came in, duly signed by Mr. Broja Jemfi, Rodu Metonunu signed against it. Do you know or you don't know?
My Lord, the documents that come to our notice is the final declarations, the signing on the regional declarations at the strong room are not brought to us.
Well, I'm putting it to you that for Ashanti, the form was signed by Broja Jemfi in Ashanti region, and
yes,
when it was transmitted,
testify.
And when it was transmitted to the strong room, as you call it, Mr. Rodu Metonunu signed it.
Well, I can't testify or deny because what happens in the strong room is within the knowledge of people who are in the strong room.
Now, you have attached to your letter 2 sheets from the Eastern region. Is that correct?
That's correct, my Lord.
On the first sheet, your agent signed the form. Is that correct?
My Lord, there are 2 sheets. I don't know which is first and which is second.
The second one is what you have. There's one that your agent did not sign. If you look at the forms, there's one, the one with the blue ink at the bottom, your agent did not sign.
Yes.
The one that doesn't have the blue ink, your agent signed.
Yes, my Lord.
Right. Now, if you put together all the valid votes assigned to each of the candidates that your agent signed, the total will be 1,196,751, and not the 1,236,940 that was written on the form.
My Lord, I have realized that the totals there are. Yes, I've looked at. Yes, my Lord, that is precisely what I'm about to do. I have done the collations, the additions, and I have realized that the totals on both sheets are the same figures, but the figures that add up to the totals are different. And the one marked in blue is actually accurate.
Now we'll come to the one marked in blue. I am saying that if you add up all the valid votes assigned to all the candidates from number 1 to number 12 on the form that your agent signed, the total should be 1,196,751 and not the 1,236,940 that was written on it.
My Lord, I can confirm that the totals are not the aggregates of the numbers there, but I don't remember the actual figure that I got. If the court will permit me, we can add and find out what it is. Yeah. But all our phones have been taken.
My Lord, my Lord, we brought a calculator.
Yes.
If the court will permit, you can do that too.
Yes.
Order in court, please. Order.
1, 4, 6. Appears your calculator is not 1, 2, 9.
Is order in court.
Lord, I have 1,196,751. Correct.
Now, kindly deduct that figure from the figure written on the form. That is 1,236,940. What will you arrive at?
$40,109.
40,000.
109.
189.
189. Sorry.
It is 189. Yeah. Good. Now, look at the last page of your Exhibit E, which is the sheet that you attached to your evidence. Listening. Now, there is a constituency there called Ayenswano. Ayenswano. Do you see 40,189 over there?
Yes, my lord.
I am suggesting to you that the second sheet that your agent did not sign was corrected to include the Ayenswano constituency results.
Well, I cannot testify to that because if there is any correction to be made on any declaration, those who are part of the declaration must be present for the corrections to be made.
Yes, but you also are aware that where the person whom you have appointed to represent you leaves and refuses to be part of the process, those who are there sign onto the form and the process continues. You are aware?
Yes, I'm aware, but
now I'm putting it to you that when the Ayenswano results were added, all the candidates got the additional votes that they got in Ayenswano, thus making extra gains to make the total value votes 1, 2, 3, 6, 9, 40. I am putting it to you.
My lord, can you come again?
I am putting it to you that when Ayenswano results that I have just shown you, that if you take the difference that you got from the first sheet from what we had written, you get 4189, and that 4189 on your own spreadsheet Exhibit E, it is spread across all the candidates. The only person who didn't get a gain was Hassan Ayarika. I'm saying that if you put it together, the gains that each candidate made in Ayenswano, the total will now come to 1, 2, 3, 6, 940. And I'm putting that to you.
Yes, my lord.
Good. Now, therefore, I am further putting it to you that the Eastern region sheet had no problem, for which you ought to have written to the first respondent.
I deny that, my lord.
Now, I am further putting it to you that the 3 remaining constituencies that your agents, the 3 remaining regions that your agents did not sign, the petitioner won those regions.
My lord, if the figures are in contention, we are not able to determine who won.
Now, those regions are Western North, Northern, and Greater Accra. I'm putting it to you that the candidate won at those regions when the coalition was done. That's the petitioner.
My lord, I repeat that if the figures are in contention, it is difficult to determine one.
Now, are you therefore saying that with respect to Greater Accra, you do not know that the petitioner won the election?
My lord, you claim my agents did not sign, which means that it's part of our case that the figures are in contention.
You see, I am putting it to you.
And in the presidential elections, regions are not won.
My lord. Go, my lord. Go, my lord.
In the presidential elections, regions are not won. There is one presidential elections and one returning officer who declares the winner at the national level. No other declaration of the presidential elections takes place anywhere else.
Right. Well, I am putting it to you that for the record, Western North was won by the petitioner, and the Western North form, although not signed by your representative, it was certified by Mr. Ruto in the strong room.
My Lord, the agents in the strong room will mount the witness box and they will be able to testify whether they signed or did not sign.
Do you still stand by your petition in this court? The petition that you filed, do you still stand by all the amendments in it?
Yes, my Lord.
Now, let's look at paragraph 12 of your petition. Sorry, the petition of the petitioner, sorry. Paragraph 12 of the petition of the petitioner. Kindly read paragraph 12 to the court.
Paragraph 12. Yeah, I'm ready.
Paragraph 12 of the amended petition, sorry, my lords. Have you seen it?
Yes, my Lord.
Kindly read it to the court.
If the total number of valid votes standing to the names of each of the presidential candidates is summed up, this will yield a total number of valid votes cast of 13,121, 13,121,101, a figure that is completely missing from the purported declaration. 111, a figure that is completely missing from the purported declaration by Mrs. Jean Adukwe Mensah on 9th December 2020 and the purported ratification on 10th December 2020.
Now, I am putting it to you that the figure in the paragraph 12 of the petitioner's petition shows clearly that the number mentioned by the first respondent as the valid vote, total valid vote, was an error, which you have admitted in your petition.
Can I hear the question again, please?
I am putting it to you that as at the time you filed this petition, you knew that the figure 13,121,111 was the correct total valid votes that ought to have been announced on the 9th, as you have said in your petition. I'm putting it to you.
My Lord, these are figures we computed from the first respondent's own data that was supplied. These are not our figures.
Well, you are bound by your petition, so let's go on. At the point that the declaration was going to be done, you have stated that your agents, Mr. Metununu and Dr. Kwesa White, left the strong room. Is that correct?
That's correct.
I am putting it to you that they left the strong room because they realized that the petitioner had lost the election.
My Lord, I can't attest or deny that one, and these are matters in the personal knowledge of the agents who will be mounting the witness box subsequently.
And they left the strong room because they didn't want to sign the Form 13.
I can't attest to that.
And I'm putting it to you that the total valid votes as at the 9th of December 2020 and captured on Form 13 is just the same as the total valid votes in the form in paragraph 12 of the petition.
My Lord, we don't know which is the total valid votes as we stand here, because the first respondent has turned out several different figures. So our case is that Ghana does not know the results of the presidential elections as we sit here now, because the petitioner who has the constitutional duty to conduct the elections has not, the first respondent who has the constitutional duty to conduct the elections and report and exact figures has failed in that duty. So we are confronted with several figures, and it depends on what you want to believe.
Are you saying that you do not believe in the figure that you wrote in your petition?
I picked up, my Lord, I stated that we picked these figures from the respondents' own calculations, not ours. We haven't supplied.
And I am putting it to you that if your representatives had not left the strong room, you would have seen that those figures 13,121,111 was the total valid votes as captured on Form 13.
My Lord, I can respond on behalf of the agents. I have indicated that one of them will be in the witness box to testify.
I am further putting to you that 8 out of the 12 presidential candidates stayed back and signed on the Form 13.
My Lord, I have indicated that the processes within that National Coalition Center are not within my personal knowledge.
Okay, we'll leave it. We'll address it.
Now, let me refer you to your form, your Exhibit E. Look under Bono East. Bono East. Yeah. Do you see the valid votes that the petitioner obtained?
As per the computation of the first respondent, yes. Because these are not figures, they are figures from the first respondent.
Right. You also agree with me that the petitioner never obtained all the 128,000 registered voters' votes from the Techiman South constituency as you purport to show in your evidence. I'm putting it to you.
There's no way in the evidence that you propose to say that the petitioner was all. Respectfully, there's nowhere in the evidence where the witness says that the petitioner got all the registered votes in Techiman. There's nowhere in the evidence to that effect. And I think this is just to kind of mislead the witness.
Amenuvo. Yes, my lords. My lords, I am not, with the greatest respect, misleading the witness. Lords, as at the date that the witness filed his witness statement on he signed his witness statement on the 27th of January 2021, he, in paragraph 12, sought to make analogies with the Techiman South total number of registered voters. And that is why I am asking him genuine questions based on his own documents that he has brought before the court.
My objection is very simple. He's made a specific statement that the petitioner, the petition says that all votes in Techiman South were won by the petitioner. There's no way. This talk about by analogy and so on. Let him point to where in the witness statement.
Mr. Amenuvo, please.
Yes. Now, yes, my lords.
He raised an objection. What is your response to that?
Lords, I'll rephrase the question.
Okay.
Right. Now, as at the time you filed this petition, I am suggesting, as at the time you filed your witness statement, I am suggesting to you that you could not include paragraph 12 because the total valid votes that the petitioner obtained were known. I'm putting it to you. In the Techiman South constituency, they were known.
As at the time you were filing the witness statement?
Yes. They were known?
Yes.
Good. I'm further putting it to you, therefore, that so I am putting it to you,
yes,
that using all the total valid votes in the Techiman South constituency, that's registered voters in the Techiman South constituency, to do your analysis is incorrect. I am putting that to you.
My Lord, the analysis was based on what the first respondent herself claimed. So all the information there, all the figures that were stated there were from the first respondent's own account when they were declaring the results. And if I may proceed, the first respondent claimed that even though they have not had the results of Techiman South, they feel secure to proceed because even if all the votes of Techiman South were to be added to the petitioner's tally, it will not change the outcome.
Yes.
So the analysis we did there was to show that based on the figures she herself declared, that statement could not be correct.
I am putting it to you that the first responders chairperson was right, because as at the time she was making the declaration, you knew that the total valid votes in the elections was 13,121,111. I'm putting it to you.
My Lord, I don't understand the question. That I knew, or the chairperson who was doing the declaration knew.
You,
because I didn't do declarations.
You, as a witness in this box, you knew about that. I'm putting it to you.
That when the first respondent was making the declaration on the 9th, that I knew that the total figures, total of the votes was 30,121,111.
Yes, because you stated so, the petitioner stated so in his petition, that that ought to be the correct number, and the first respondent in her answer agreed with you. So I'm putting to you that you knew.
Well, Lord,
answer the question.
I don't understand why you seem to be confusing me with the petitioner. Because I don't understand.
You see, that's why we have to strike out some of the evidence. Because you can't speak to them. And so that's the basis upon which we have to strike out some of the evidence. And we are confirming our position.
Oh.
Lord, I'm still waiting for the answer.
I'm saying that I cannot answer for the petitioner. You're asking me questions that ought to be asked to the petitioner, right. And I'm saying that I'm not.
So,
I took these figures from the respondent's declaration. Now, and before they were declared, I couldn't have known what he was declaring.
Now, can you read paragraph 13 of your witness statement to this court?
My Lord, paragraph 13 of my witness statement. When the percentages of valid votes cast and standing to the names of each of the presidential candidates. Oh, my witness statement, okay. Witness statement. Have you taken? You've taken the witness statement.
It's over there. Let me show you. Bring book.
It's here. Paragraph 13. Yeah, paragraph 13. The Techima and South constituency has a total registered voter population of 128,018. And if added to the total valid votes announced by Mrs. Jane Adukwe Mensah as cast, which is 13,434,574. The resultant figure would now be 13,562,592. Consequently, if all the votes of the Techiman South constituency were added to petitioners' votes, second respondent's vote will remain the same at 6,730,413, now yielding 49.625%, while the votes of petitioner will increase to 6,342,907, now yielding 46.768%.
So I'm putting it to you that you knew the results from the Techiman South, and therefore this analysis of yours is incorrect.
My Lord, I beg your permission to quote paragraph 12 of my statement. That will explain the meaning.
Please answer the question and you can explain.
Okay.
Answer the question. I'm saying that at the time you were making this statement, you knew the exact results of the Techiman South constituency, and therefore the analysis that you had made was wrongful. Answer the question, yes or no. If you want to explain, you explain.
The analysis was right because it was based on a statement made by the first respondent at a certain point in time. So if we are analyzing that statement at that point, I don't see how you bring in the current situation to be able to answer that statement.
I suggest to you that you are wrong because the current situation is the reality. The court deals with reality, not conjecture. I'm suggesting that to you.
My Lord, the current situation cannot be the reality because nobody knows the results of the presidential elections in 2020. Nobody knows in exactitude how many votes each of the candidates got and what percentage each of the candidates got. And the first petitioner, the first respondent, in her own words, and my Lord, I beg to quote in my own statement, currently, the election results we have declared exclude that of Techiman South constituency, with a voter population of 128,018. The third election results are not ready because they are being contested. Even if we were to add the 128,018 full results to the results of the second candidate, it would not change the outcome of the election. Hence our declaration of the 2020 presidential results without that of Techiman. The respondent was justifying why she had to declare results based on uncompleted tally. And we are questioning that statement, that statement could not have been correct as at the time it was being made.
I am putting to you that as at the time the first respondent's chairperson made that statement, the statement was correct and it is captured in paragraph 12 of the petitioner's petition.
I decline that.
Now, what was the source from which you obtained information to draw up your Exhibit E for this honorable court?
My Lord, Exhibit E was based on the first respondent's own data.
But you have gracefully brought it to the attention of the court. You want to rely on it. Is that not so?
Yes, we want to rely on it to the extent that we want to prove a case against the first respondent.
No.
And I'm comfortable, I'm a teacher, my lord.
Now, my lords, in Exhibit E, there are votes assigned to the petitioner and the second respondent and all the other presidential candidates. Is that not so? That's on the last page of Exhibit E.
By the first respondent, yes.
Now, what we have here is 677-6066 for the second respondent. Is that correct?
From where, please?
That's the total, the total valid votes.
Yeah.
Is that correct?
6,776,066.
That's what is on it. Is that correct?
I don't know. Yes, it's in this statement.
Yes.
Yes.
And then also for the petitioner, we have 6,265,276. Is that correct?
According to this document submitted by the first respondent.
No. It is your document we are looking at, please. Now, look below the figures we have just gone through. For the second respondent, there's a percentage of 5.126. It is down there. That's 51.126. Sorry, 51.261. The way we have rendered it, that's why. 0.5, yes. 0.51261472. Is that correct? That's correct. Now, I am suggesting to you that this works to a percentage of 51.2614. A percentage of what? A percentage of the total valid votes also on this sheet. It's 51.263%. Right. Now, for the petitioner, we have 47.397 assigned to him by your sheet. Is that correct? 47.397. Yes. Right. That's correct. Now, deduct the number assigned to the second respondent. No, deduct the number assigned from the petitioner from that assigned to the second respondent and tell this court the difference. Which of the numbers? You asked about percentage. You are now asking. 6, 7, yes, I've moved on from percentage. 6776066 minus 6265276. What do you get? 677
is not that good. I think you'll be stretching the witness about 510,790.
Thank you very much.
It's okay.
Yes. You got 510,790.
Yes, my lord.
Right. Now, it is not true that the first respondent padded evils as you allege. I'm putting it to you.
My lord, I declare to that assertion.
Now, in your exhibit F, you allege that 4693 votes was added in favor of the second respondent. That is your allegation.
My lord, if you look at my statement, I indicated that I will bring a sample of the constituencies and polling stations where padding took place. I did not indicate that is an exhaustive list of all the places where the padding took place.
So we are using the numbers that you have brought to the court to assist the court. I am saying that the total of 4693 is what you have put in there. Is that right?
I brought it as a sample. I did it in my statement, actually indicate that this is from a sample of this particular perspective. I don't understand sample to mean total of the population.
Now deduct the 510,790, we deduct the 4, deduct the 4693 from 510,790. What do you get?
With all due respect, I don't see the point of the
greatest respect. You are being rude to the court, not rude.
Okay. Yeah, come again.
And so that we deduct 4693 from 510,790. What do you get?
I got 506097.
Good. I am suggesting to you that even if this your number as alleged, which is denied, even if it is deducted from the total valid votes of the second respondent, he still has won by your own sheet by 51.246%. I'm putting it to you.
My lord, I deny that because you are subtracting apples from mangoes. But this is a sample. You want to take a sample from a population of another. I don't see where the calculation is coming.
You see, I am suggesting to you that you have no evidence to support your allegation. That is why you have brought only what you have. I am putting it to you.
But we are not in court to try to declare another presidential it was by us. We are in court to challenge the performance of a constitutional duty of a first respondent and to see whether that duty has been discharged faithfully.
If that is so, then I'm suggesting to you that you are not, by your own showing, you are not in the right forum.
I claim that, my lord.
Now you have earlier told this court that you cannot speak to what happened in the strong room when the two representatives were there.
Yeah.
Is that correct?
That's correct.
Because on that basis, I'll end my cross-examination of the witness.
Yes, my Lord. I do. So, Mr. Asidun Katia, you recall that before the declaration of 9th January 2021, December 2021. Relax. 9 December 2020. Your party and your presidential candidate held a series of press conferences on what you consider to be the outcome of the elections. Is that not so? It is so, my Lord. In those press conferences, you announced to the whole world that the petitioner had won the presidential elections and was by the votes you had collected the president-elect. Am I correct? My Lord, that is not in my witness statement. So can you answer that question? You did say so, didn't you? Come again. I said your party, including your good self, and the first petitioner, the petitioner, and also one Otokuno, your deputy, together with other leading members of your party, you held several press. So, I'm putting to you that your party held a number of press conferences. Yes, my Lord, that is so. Now, in those press conferences, or in some of them, you were present and you spoke on the issue of the results of the presidential elections. Yes, my Lord. The petitioner himself also spoke on the outcome of the presidential elections. Yes, my Lord. And your as deputy, Tokuno, equally spoke on the results of the presidential elections. My Lord, I can attest to my statement at the forum where the petitioner was present and he spoke. But I don't remember being present at a forum where my deputy spoke. presidential candidate, that is the petitioner, asserted that he had won the 2020 presidential elections. Ghanaians had voted for change.
And what I remember the petitioner said was that the results are declared by the first respondent is not accurate.
Now, I'm also putting it to you that you yourself declared that the petitioner had won the presidential elections.
Unless I'm reminded, but I remember saying that NDC has won parliamentary majority in parliament, and that gives President Mahama a comfortable situation to be able to run the next government.
So I'm suggesting to you that by that statement, you were saying that the petitioner had won the elections and was going to become the president.
But there were all indications that he was going on.
It's not indications. I'm saying that by what you said, you meant that he had won the elections, because that was the only way he could form the next government.
And Lord, if I meant that, I would have said so.
Mr. Asegu Iketia, we served on the petitioner our witness statement. You are aware?
Lord, I'm not the petitioner.
I didn't say you are the petitioner. I said we served on the petitioner our witness statement.
Yes, I'm aware we have been served.
Have you seen a copy of the witness statement?
Yes, I've seen it.
Do you admit that in the witness statement of the petitioner, of the second respondent, you have attached Exhibit 6?
Exhibit
6. 6.
Yes, sir.
Hours, we are looking for hours. Yes, can you answer?
Yes, I've seen this.
So we presume that you know the contents. So we presume that you are speaking, you know the contents of that video clip.
Well, my Lord, I have not played the contents, so I cannot testify that I know what is contained there.
My Lords, I would need some direction here. This is a problem that arises at trial in the High Court. Our witness is not at that moment giving testimony. A witness on the other side is giving testimony, and you want to confront him with material or exhibits in your witness statement. In our witness statement, to discredit him, what he's saying. Now, at the time that he would have finished his evidence and stepped out, he will leave that evidence. He will not be available to respond to the content of that evidence. You want to play the video so that you exactly. Yes. Very well. Yes. Mr. Mutuampo. Yes, my lord.
You are conducting your case, so if at a point you think that there is evidence which you want to make an application to the court to allow you to either show to the court, you have to put that application before the court. But as it is, you have not made any application. You have to give the other side the opportunity to respond. What you're asking is you want directions from us.
Yes.
So you know what to do.
If you leave an oral application to have the video that will attach to our witness statement played out so that we can properly confront the witness with his own acts and that of the petitioner, together with leading members of his party, on the issue whether or not they declared to the Ghanaian public that petitioner had won the election.
You have to address us on relevance. So what is the relevance? What would this video establish?
The relevance is that the petitioner and his supporters or his leadership led Ghanaians to believe that they have won the election and that there was an attempt by the first respondent, together with, in collusion with the second respondent, were trying the will of the people, and that they had all the necessary ink sheets to demonstrate that they won the elections. When they came to court finally, after a lot of pressure from the public that if you won't come to court, all they are saying is that if you use the errors in the chairperson of the first respondent's announcement, then neither party has won, so they should get one. It goes to their faith, good faith, credibility.
Well, Mr. Kutuampa, anybody at all can call a press conference and declare himself or herself to be the winner of an election. And you mean because I called a press conference and declared that I won an election, that should be taken as the law?
No,
No. We have laws, we have regulations, and how we know how to declare our results.
My lords, where a major party in the republic, like the NDC, is mobilizing its...
Mr. Kukumba, you see, the witness is denying these allegations. Yes, that is why you have your witness statement together with this, would I say, proposed exhibit or whatever, served on him. If it is your time, or if your time comes, then you have to put in.
Yes, my lords, what I'm seeking to, I'm actually applying to the court for leave to play the video and use it because it's part of our case, and use it to cross-examine the witness. And my lord, I'm saying that this is a difficulty.
We are talking about credibility. We want to establish credibility.
Yes, yes. So you haven't said so. No, my lord, I said it goes to his credibility. I said so.
Once you put this application in the rules, I mean, you have to premise your application in the rules of court and in the Evidence Act. That's your job. That's your burden.
I mean, our application is relevant to this petition to the extent that it demonstrates the credibility of the petitioner in respect the credibility or lack thereof of the petitioner in respect of the 2020 presidential elections. And yes.
So what is your submission? What is your submission? What is the application that you want us to?
My application is a leave for the video.
Confronting with the exhibit?
Yes. Because he's been very evasive, almost to the point of denial.
The challenge we have is that you did not give any indication prior to this hearing that you want a video to be played.
My lords, it's attached to our witness statement that I believe all your lordships have copies of. And I have every reason to presume that you know that I'd like to play it.
I'm not sure whether the registry, Mr. Registrar, I'm not sure whether there is any provision made for that. Do you have?
That we have not been heard. There have been several steps question. We have not been even in respect of its basic okay.
You can reply. Submission. The application. She said he was making an oral application.
Right.
Yes.
Yes, that's what I was saying. That my understanding was that the question from His Worship Justice Amega was about the practicality of implementing that.
Yeah, it has not been granted. So you have to
that, and we want to see that in fact, literally, was in the box. He opened the envelope. It should be put to him. That witness statement is not in evidence. It's not been adopted in evidence. So how my the procedures are simply being confused
from this witness statement, which is an invention into our rules. Well, you see, in CIA 87, it is
if it's not evidence yet, yes, that is why they can do what they are doing. Because no longer it's not evidence until they come to the boss, yes, and adopt it. It is no evidence. So it's like they are having a document. They want to confront the witness with the document.
To be sure. So that is what I'm saying. And so we're in a situation where the practicalities do not allow
the equipment that can be used to play to video to the witness. That is the case.
Mr. Professor, even if we were not in an era of case management, where you bring you show all your evidence, you still would have access to this through the Evidence Act. It's just about electronic evidence as compared to paper evidence. And so the system has to be set up if you apply fully.
You have actually notified the registry that we would be needing there was that is why I made the application.
My lords, once you're considering these practicalities, I would like to indicate that we would, by the same token, especially once the technology is available, we would wish to have the declaration made on which is testified and which is part of our witness team, the declaration made by the chairperson of the first respondent to be played also. We have the exhibit, so we would also, just for the sake of completeness, because while we are discussing all this technology, I think exactly, that's all I'm saying.
counsel for the second respondent wants the court to have access to the content of a prospective exhibit which has been annexed to the witness statement. As this attachment is not in evidence now, we hereby order that it should be placed on the next agenda date for us to ascertain its admissibility on the grounds of relevancy. Yes. Yeah. My court, the petition is adjourned to Monday, the 1st of February 2021 at 9:30 a.m. for continuation of cross-examination.
You have to start.
Please, you've not been discharged. So Monday, they may continue to conduct the court examination.
Very well, man. We are ready to collaborate with the registry to provide the necessary facilities, if need be. Very well.
Thank you for your unsolicited assistance.
Ura Mahama and Irini.
One touch.
Miaminia Kuma Michia Nesisia Samijamfi, who can be said president elect. Now Konuye. Nanso, Nipa Bebre, Training Musenka, Ura Mahama de case Iba Supreme Court, no Becase. Yenka Abatunum Ura Kufadu and Rini. Nemo Ura no Mahama no Rini, Nakayanka say Supreme Court enkansi so senior 2013. And Kufadu the bar court. So Akoya Ngwa say omoba court no Ura Mahama say we Nemo Ura Kufadu nso Rini. Enti no eba ne saga yenkoto aba no mo mumie nya na gum nya kradon kom nya info mu sinchen. Enti ehon ye just say enti o de tron semo a sebi ono ani na pamfo ekan ya e ma supporters bebrani giye eni be bi anka esese otimi kansi susampa mi wini ene bi a ye wia me no antimi ameka se mpo ye wia no na wanso antimi ameka se me na mi wini ye ne ye bu mi bukata no eno ne ma krofo bebre adwemu ye omna ka krenti e bi adwada ye bo video no ana tape na munyam be hebi atie bi na se bi munyam ye badwema na motimi di mani ni maso nyina abu ba bi ejina no no tie dama se
Good afternoon, ladies and gentlemen of the press. I want to start by letting you know that today was very eventful. And I'm sure when you watched the proceedings, you came up with the impression that the John Mahama team brought a solid case to the Supreme Court. In fact, when we filed the petition, it was being bandied about all over the place that our petition was empty, that it had not disclosed a reasonable course of action. Well, today was your answer. I am sure you saw vividly the evidence that was being led by the General Secretary. We have not yet concluded the hearing, and so I will not comment on the merits of what he said. But I'm sure you are all witnesses and you know that this is not an empty case. Now, let me correct one misrepresentation, very deliberate and gross misrepresentation that lawyer Frank Davis, my very good friend, has made this afternoon. He sought to give the impression that we came to court because we wanted a relief to the effect that His Excellency John Dramani Mahama be declared the winner of the election. I am sure, as ladies and gentlemen of the press, you have read our petition. Nowhere have we sought that relief from the court. What we have sought from the court is very simple and may be summarized in two. First, we want the unconstitutional conduct of Jean Mensa to be held to account. Secondly, we want the court to declare that none of the candidates met the threshold requirements of Article 63, Clause 3 of the Constitution. That is the crux of our case. And that is the case that we have sought to make in court today with the witness statement of the General Secretary of our party. Now, it is far from being the case that John Dramani Mahama himself must testify in this matter. He has filed a petition. He is entitled as of right under the law to call witnesses in aid of his case, and that is what he has done. In 2013, His Excellency Nana Addo Dankwa Akufo-Addo never testified. Ladies and gentlemen of the press, if you have evidence that His Excellency Nana Addo Dankwa Akufo-Addo testified, please bring it to us. He did not testify. He called witnesses to testify on his behalf. So is it the case that when it comes to His Excellency John Dramani Mahama, the law must change?
and compel him to testify. I am surprised that a senior lawyer of Frank Davis' stature is confusing petitioner with witnesses that the petitioner calls. Also, it played out in court today that if we had done proper case management as we were pushing, we would not be where we were this afternoon. You remember we complained bitterly that case management, as stated in CR 99, was supposed to last 5 days. The court compressed it to 2 days. And in fact told us that we had spent the first day of those 5 days making the case for the interrogatories. Now it played out in court today. The importance of case management. When they sought to tender the pen drive that contained the so-called videos in which principal officers of the NDC and our presidential candidate made certain statements, you saw what happened. The court was not prepared to play that video because it had not anticipated that it will be needed, and there was no equipment in court for that purpose. As practitioners, we know that at case management that issue would have come up, and the court would have been prepared that on day 1 of the trial, a video will be played showing evidence of statements that our principal officers made. Ladies and gentlemen, it is very important for us as a party to underscore the fact that we are not in this case because we want to joke with the Ghanaian people. At the end of the day, the issues of accountability, the issues of the mathematics of Article 63(3), and you very well, you saw it in court. When calculators were flying around, were we the ones who brought the calculators to court? Were we the ones who brought the calculators to court? But we warned you that this case, a big plank of the case, concerns the mathematics of Article 63(4), whether or not Nana Addo Dankwa Akufo-Addo, as a presidential candidate, crossed the constitutional threshold of more than 50% of the vote. Our case is that he did not. And we will prove that in court. Just watch out in the next few days. Any questions?
Impact on the case as you have put together?
No, we don't think it has any impact on the case we have put together. We are allowed to bring those matters back, when cross-examining their witness. So we don't think that it in any way, destroys our case or minimizes the probative value of whatever evidence we are bringing. But note that they raise the objections based upon the so-called scandalous nature of some of the averments or some of the statements in the witness statement. All right. Now, we had alleged that she acted in a biased manner, in an arbitrary manner, in a capricious manner that was motivated by personal dislike for His Excellency John Dramani Mahama, or if you put it in the converse, her likeness for Nana Addo Dankwa Akufo-Addo, her preference for Nana Akufo-Addo. And that is how come that in our witness statement, we sought to make it abundantly clear that she had a familial connection to the Akufo-Addo family, that she is a relative of Her Excellency Rebecca Akufo-Addo. Now, if that is not material, what is? If you are a family, a relative of the First Lady, are you telling us that you don't want her to continue to be First Lady? So we said that she did it, with a predetermined agenda designed to continue, to let her sister or cousin continue to be the First Lady by announcing that Nana Addo Dankwa Akufo-Addo was the president.
So you have made it clear to us that the petitioner himself will not be in the box and that he has assigned witnesses to make his case for him. However, in court, at least more than 5 occasions, the petitioner's witness declared that he was not the petitioner and therefore did not answer certain questions that were thrown at him.
Well, that's an excellent question. It means that you were watching the proceedings. Let me make it clear that in those instances where the witness said that he was not the petitioner, they wanted the witness to give evidence with respect to the state of mind of the petitioner. Okay? Anything attributable to knowledge that is within the personal, knowledge of the petitioner. I mean, how do you expect a witness to be able to testify to those matters? And that is how come that he legitimately declined to do so. It is not because he is distancing himself from the petitioner. In fact, he is not here under compulsion. He voluntarily agreed as our General Secretary to testify because he is the chief administrator of the party. He coordinated with the help of the chairman and the other principal officer. He coordinated the election. So who better to testify on our behalf than our General Secretary? And that is precisely what he was doing. But if you insisted that he should speak the mind of the petitioner, he should testify to matters within the knowledge of the petitioner, he would decline. And that was just as it should be. And in law, the General Secretary was right in declining those questions. Any other questions? All right. Thank you very much, ladies and gentlemen of the press.
Okay, so let me just do the let me do the for your best friend Yatre and the course the Supreme Court of Ghana mu ewutwi kasem na ansakra na metre de Dr. Ayine aka no poto kasem wutwi kasem mu no Frank Davis oye kasamafo ema the second respondent eye Nanado Danko Ekufuado aka nsem bia ewo se yeyi ano na ma Ghana for anye sebio sa inkontumpu sem no antum dedi kan samutie ni a oyusu word bi say about 10 passages na ewo General Mosquito witness statement mu no omo ka say court no mu na court no bo mu sungu ye because sansem no a pedestrian chese sebio e yakushisem obisanfo mu nyina mo hwe de course wo court ni bi with TV so court no bo sa nsemfuanso na gu no court na nka ba bia se e pedestrian court na nka se yakushisem omu person ka court no bo sansem na gu because e yakushisem e scandalous the court na ntie the court no ka ya ne se wa bo sansem so no agu because say any your petition the dear friend of pleadings it has no foundation in the pleadings. That is different from some Obeka say and someone a General Mosquito adanse crater muno a pedestrian. Now you pay attention and you raise this issue because of Bibi second respondent Suban say maybe I be free court abahabiano or be you suka sepie and se bi semwa eni se free alo for ano e de akasa fa de course wo court. The last time it was intransigent and right it was somebody who had a jaundice mind and there will be a ne passages here pedestrian ya besre ni diem say a lawyer for we adifie mu ni atete ye wo kwan ya wo se ye fa so kasa and it is a free court na wa ba be kan samwa akoto a the court unkan kan she court na no if the court in dismissing or upholding those 7 objections did not say say pedestrian imagine bedroom meka that conduct is unbecoming of a lawyer of the standing of Frank Davis. The best stress ye nyina ye be condemn say ne be ya enkoso because ebetimi aha asemo a court no edi the atosu biem okase omampanyi John Dramani Mahama ode na asema ba court o ye petitioner no onfa dance kata bia maaye enu nti no no kire se oni asem bia they said the doctor in chechire mu opotoka sem no sa asem ne so eye mfuturu a yenuanom etu ganafo ani because wo mramu no sa wo de wasem beto court anim se court nka wasem as petitioner bibia ni wa hye wo se e wo se wa obedi adanse ma ho emra ne ma ho kwan se utimi fra adansefo ma adansefo ebedi adanse ma eno ntina in 2013 election petition no o mampenye kufu adode na asem as the petitioner no ono wa medi adanse ni bi wa ma obi aso mra krata the power of attorney se o mejina nenamu eya adansefo Dr. Bawumiamo eno so mo obedi adanse ma no enti de yewura John Mahama aye no edimu ewo mramu abiboni bi ani ti nsemu a yenuanom kan ne no so no eni nyina so bia wo mram ti e be stress eno se beto nchen ebiem okase NDC for emra ya to aba ni wie on 7 December ye ka kira wi ase nyina se ye coalition ye nkonta ye bu kire se ya win election no but ye ba court no ye ka asem foforo se court no order for runoff na no kire se ye witness ase edu ketia ne NDC for ye nya no kwafo obobo ye nyina ye di ne de keka ho abusuafo sa semi a ye nuanom MPP fo aka ne he ye o maka ne bebi bebre no ye chende pa ne se ya semu a ye de aba court no o monti ase yenti ya kasa ne se ya semu a ye de aba court no has got nothing to do with the coalition ayaye ene ye figures ayewo wo mramu no se obi tia wo na so mprem nu na wo the lawyer for fellow two courses of action against the person wona wo be choose the wo de be court kane enti ampa ya press conference based on pink sheets ne results ayewo your coalition yaka say John Dramani Mohammed Nkunim but assemble ya the court and that is not the nature of it. Assemble ya the court has to do with the constitutionality of the declaration ya jimensa aye. Yes, the constitution say who declare obi say wa weni o mampenyi abatoa. E was say nipa kro no wenya emapanu mu ohamu chichemu adunum ni akire. The in figures wa declaration mampenyi kufu adu enya. Into we declaration ni tiaga na mra ku 1992 constitution. Not just a mremuno declaration doesn't even exist. So if the declaration doesn't even exist there, then issues about the coalition, in the view of our lawyers, so we have elected to challenge the constitutionality of the declaration of Jimensa. That is what is in court. At the appropriate time, say was said. Ye kasa about the coalition ya ni adanse ya ni arena ye beka nwasem but let in some way ye kan about the course of court no ye man fa in some way that court nanim which is about Jimensa adwuma waye about wa wabobo any whether or not to say edimu results are declare no edimu ewo emrem abusianfo ebiem o ka say oh Yewura Johnson na say du keti adanse mu no o ka say he is not John Mahama the petitioner. Inti ano no kire se Yewura se du ketie nim de oka na petition ni masem. O de ya ne se a lawyer fo a omunim de. Pa o mote sanse mu yase no. E maybe e be fi court abia no maba no mutu fitu Ghana fo ani. Utie de fa de bisankaza kan ya. O se paragraph 2 of Yewura ase du ketie dance krata na wo say he's giving evidence in support of the petitioner. In support of the petitioner, that means I am giving evidence as the petitioner. What that means is as a witness, evidence or the support to petitioner in case what the lawyers will say matters within his personal knowledge. It is over this and the question say now central for share movie as Mama will be a wajatum, a one on your petitioner because I know the only now babies and the questions are petitioner no the money can't be and I didn't know only Timothy or ye bibia. Measures and someone who pass or cano. They are not within this personal knowledge and me on one casa need them to a man what dance your crowd tombra. That should show you say and now you penny mupa or dear dancer no or you're no call for. He's credible. Say in some way within the personal knowledge in Kwano Beka Wansen. That was your for Yeba the course or court in Muno. A course or court. The Moshe say wa win no 30,434,574. Yekoye nkonta wankasa waye no o declaration ni mu a omanpenya kufu ado awene per wankasa wo figures percentage awodi ama no enye correct. Azon hia waye say ye detachment south nyina ka ne ho a still candidate Mahama Nsan ne ho enye correct. Kwansi na de achen ya na wasan so at the press release I don't be Nsan Shasi aba. And also total valid votes are what they boom kunta car so man penyo for awene ye sen a. They say the 13,434,574 bim. Almost say 13,119,460 na figure na sa. And no ma ka cha ma Ghana fo nyina gie di so ma me ne yemfonso wa correct ne fonso. Afeye Rajon Mahama e dey asem way back court. He say ma meji mensa. Betre yen madodo a wugina so di declare say John Mahama renia. Correction nana barenia. Correction oye no 10th December eno na Ghana for mu nyina magye di say no na real results no what atwene baby. Paragraph 12 and paragraph 24 of her answer to the petition. Also they say the figure no enye 13,180,460 na o kan the 10th no. Na 13,121,111. There is the figures na ya miensa. After your website also with the 275 constituency summary sheets ago. Obi abetimi akwa akwa na wakan ne wahu abato no nsunsanso. Ne ye kokeka siani a total valid votes ne yesen a eno so 12,218,633. Na just abato ba akwa yato. O results nko aburo na nyekire. Debia esesa. Na eno nana Yewura Johnson said Ketia eka ho asem say that is the issue before the court, and we are saying say so wutie ma me nankasa nu mu asem ni figures or the two dwa no na eno ne yesi ye de be ye adwuma dia ene eno mampenya Kufuado enya more than 50% of the total valid votes eno nti wani nkunim enti abusuafo de ne course so court in the court tu ahye say ejoda ye beba na Yewura Johnson na said Ketia waba ababetoa na dance so na yeba eno so de besi dia no ye ne mo ebedi hu komite na wase.
Thank you.
You are going to...
Thank you very much. And that was the two press conferences held by the petitioners' side and that of the second respondents. And of course, the case has been adjourned till Monday, the 1st of February, for cross-examination of the petitioner's witness, in this case, the General Secretary of the NDC, Mr. Johnson Sedun Ketia, to continue. He was first cross-examined by a lawyer for the petitioner himself, Mr. Chachuchi Kata, and then by a lawyer for the first respondent, lawyer Justin Aminuvo, and then Mr. Akoto Ampao, the lawyer for the second respondent, began his cross-examination but did make a request for a tape to be played. Facilities for that tape to be played were not immediately available, and the court has adjourned till Monday, and that's why we'll bring the coverage to an end. We'll return on Monday to bring you all the other details. Thank you very much for being a part of this coverage. See you on Monday.